Any mention?
No mention. Yes. MS Colony, something to mention? Okay. Right.
Any mention?
Lordship, I beg to mention item number 16, Lordship.
One
I'm
second.
praying for 2 weeks.
1 second.
I'm praying for 2 weeks' time, Your Lordship.
16.
Well, I pay for the state responding to objection, madam.
They're not there also.
Yes, madam.
And you are for?
Item respondent number 7.
No objection?
No. I'm for respondent number 5.
Okay, 2 weeks. Yes.
Obliged, Lordship.
Your Lordship, I beg to mention item number 18, Your Lordship. I pray let the matter be taken up after 2 weeks, Your Lordship.
Why?
Not really, Your Lordship.
That's not an excuse. 1 week, okay.
Obliged.
Obliged,
1 week.
Yes, Your Lordship.
May please,
Mr.
Your Lordship.
Lalu.
Lordship, I beg to mention item 25.
Please pick up item number
25, Your Lordship.
25 or 5?
25. 25.
25, you taking a consent?
Your Lordship, I pray that this matter.
Yes?
Lordship, that this matter may be taken up after 10 of May, Your Lordship.
10 of?
May.
Because his senior is not here.
No, Your Lordship.
Yes, please, Lordship. Lordship, on the previous day we had filed our counter affidavit, Lordship, and the petitioners had requested to file their rejoinder to me.
Is that correct?
Lordship, we have just received the affidavit from the MECL.
No, but are you filing the joinder or not? You're not filing?
No, Your Lordship will take instruction about that.
Then you
We
say
just
that,
received
Mr.
that.
Adjournment. Mr. Ilalu, please that this matter be adjourned after 10 May due to the unavailability of the senior arguing counsel. He further submits that the joinder be filed in the meanwhile. If so advised, yes. Yes, after 10 May.
Lordship, similar prayers for item 26.
26 also.
Yes, Lordship. Lordship, let this matter.
Okay, 2 weeks, yes, 26. 23 matter.
Obliged.
Highly obliged.
Lordship, I beg to mention item number 31 and 32. These are connected matters, Lordship.
Who's for the petitioner?
Ma'am Susan.
Actually, in this, we got to know about there is some development. We got to know about the status of the case, Lordship, of the old case.
Before the Additional Deputy Commissioner?
Yes, Lordship, because after under scrutiny that committee that day, Lordship, there was we found that the vigilant officer also he was not aware of the case. So we inquired from the PI and all. We checked the general register maintained by them for the year 2012 to 13. So we got the copy of this, Lordship. We applied the certified copy, but we are yet to receive the certified copy, Lordship. They are unable to locate the file, so that is taking time.
What is this?
This is the FR has been submitted in that old
What's
case.
this case about?
This was because for that impersonation,
the complaint
Lordship.
regarding your shelter.
Yes, Lordship. So in fact, Lordship, they had even filed their FR.
Okay. Here is FR's mistake of fact, huh? Yes?
Your Lordship, on the last occasion, the petitioner was directed to appear before the scrutiny committee.
We appeared, Lordship.
And then?
And now, Your Lordship, they had appeared before the scrutiny committee and they fixed another date, Your Lordship, for further examination of the matter. And the next date is after the elections, Your Lordship.
Anyway,
on the 22nd.
this is matter after 3 weeks. Yes.
No, Lordship, because with regard to the
As
old
there have
case,
been-
as it is
there have
already.
been certain developments in the matter. I'm not recall anything. This matter of the 3 weeks for the orders. Yes.
Highly obliged,
You
Lordship.
take this back.
Obliged.
May it please Your Lordship. Your Lordship, I beg to mention item number 23, Your Lordship. I'm for respondent number 3.
20.
3, Your Lordship.
And for the petitioner, my lord, let it be taken up next week.
Next
After
week.
2 weeks or 1 week?
1 week, Your Lordship.
After 1 week, yes.
The interim order may continue, my lord.
Interim order is there. Interim order will continue.
Obliged, lord.
Much obliged, Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item 17. I pray for 2 weeks' times.
On behalf of?
Mr. P. Ubin.
After 1 week, yes.
Your Lordship, I beg to make a mention on party of the hearing list, item number 27, on behalf of S. Shyam.
20.
27. S. Shyam.
On behalf of?
S. Shyam. So this matter may be listed
Where's the
after,
petitioner?
after 1 week.
No objection.
After 1 week, my lord.
2 weeks, yes. 23 years.
Much obliged.
2 weeks.
I beg to mention item number 20 and 21, Lordship. I am authorized on the Lordship.
Why you have to go and vote?
Yes, Lordship.
Yes.
I want to leave.
Or you are engaging in campaigning?
No,
It's
Lordship.
over now campaigning, 48 hours.
I'll just go and cast my vote, Lordship.
Last time we went campaign, you said, no?
Yes, Lordship.
Yes. Your candidate lost last time.
Lost, Lord. 10 votes, Lordship.
That's why they don't want you to
10
campaign
votes.
for 7 years. 2021 after one week.
Highly obliged, Your Lordship.
May it please, Your Lordship, beg to mention item number 13, Your Lordship. 13 and 14 are connected, Your Lordship.
13?
And 14, Your Lordship.
What about 13? The city is ready.
Yes, Your Lordship.
Part had matter, correct? No.
No, Your Lordship.
No, Your Lordship.
Yes. What to do? Why? Senior not available.
No, Your Lordship. Personal difficulty, Your Lordship.
1 week or 2 weeks? 1 week.
1 week.
All right.
Right.
To try to dispose it of his. Yes.
Lordship, I beg to mention item number 28, Lordship, on behalf of 28, on behalf of J. Shila, respondent number 5,
On
Lordship.
behalf of
J. Shila, the conducting counsel, Lordship.
No objection.
Is it matter regarding teachers?
No, that witchcraft matter. We have also filed an additional rejoinder affidavit in this matter.
What's happened to that witchcraft matter?
Now there's certain development also. Now it's never ending. We have mentioned it in the rejoinder affidavit, which they have, the villages now, they have interrupted the water supply pipelines. They have disrupted water supply pipelines.
Stop water supply also?
Yes. The electricity connection. And there's one scheme which was granted by the sub-divisional officer regarding to low-cost housing, construction of a low-cost house. That also has been objected by the sort out the village and now has been stopped.
We'll have it next week.
Next week, my lord.
It's in hearing. Yes, this matter next week is this on 23rd. 23rd. As a fixed matter.
Highly obliged, Lordship.
Because also this is matter. Adjournment been sought on behalf of Mr. Jiringdo J. Chala, appearing as so stop. Mr. Shongwan, the counsel of the petitioner, submits as a sub urgency that the matter be tabled next week. So according to this matter, 23rd. Yes.
Supplementary list, item number 1.
Please, Your Lordship. Lordship, here an order was passed by the village village court, my lord. Village court imposing a fine of rupees 500 to the private respondents, my lord. Thereafter, the 500 each, my lord.
When? With regard to what offence?
In regard to, they went against the resolution passed by the village, my lord. So that particular area, they made it into a reserve forest, my lord. So, but these people, they started cultivating in that reserve area. So in view of that particular issue, my lord, the petitioner herein, they filed an application before the village court, and the village court, after taking evidence and recording the statement, my lord, passed an order. So, but they did not challenge the order of the village court, my lord, even after a lapse of 90 days. So,
when was the order passed by the village court?
Village court, my lord. It's page 30, my lord. It's 4/8/2021. The translated copy is at page 31, my lord. The relevant portion would be page 32. If I may be permitted to read, my lord, the last paragraph. After going through the entire statements and conducting the spot inquiry, it was found that there was no arecanut plantation prior to 2006, and that the only person who was selling arecanut was planted only after the year 2006, and that person has been selling arecanut only for past 3 years. Upon checking all the meeting resolution and rules of the villages passed in the year 2006, it was found that indeed every year the letter was informed to every villagers regarding the passing of resolution of so-and-so as a reserve forest, which was unanimously decided by the public during the general meeting. After scrutinizing all the facts, it was found that the people who were involved in the cultivation and farming activities were found guilty, and as such, the Nokpa and the people residing in the said Akang are hereby directed to continue preserving the disputed land as reserve forest, and also directed the Nokmas and the Amharis to cease the cultivation and farming over the reserve forest. Samanda village court members hereby pass order that the people involved in cultivation and farming activities.
They are not named here, Mr. Momin.
Lordship.
The people not named here who have been fined. It's here, opposite parties who Wanjang Sangma.
Yes, my lord. It's there, my lord.
Okay. Yeah, what happened after that?
In the front page only, my lord.
What happened after that?
After that, my lord, they did not challenge this order, my lord.
They were aware of the order?
They were aware of this order because they were there. No ex parte. They were there, my lord. So after this, my lord, the petitioner here in my lord, they filed an application under Rule 53 of the Administration of Justice, my lord. And before the Chief Executive Member, my lord. The order is at page 39.
39.
My lord.
Yes.
So the relevant portion is para 3, my lord. It reads, as per Rule 53, Sub-Rule 2, whenever an application is made under Clause B of Sub-Rule 1 of the aforesaid rule, The application is to be considered as a decree, only which need to be executed keeping in mind of the spirit of CPC. This being the position of the case, I have tried to execute a decree by summoning the accused person, respondents, but they did not cooperate and failed to appear in my court. Since all options have been exhausted, hence left me with no other option but to forward move this case to the Court of District Judge, Additional District Court, my lord.
Yes.
So thereafter, my lord, an application was again filed before the District Judge, my lord.
For execution of the 500 rupee decree.
Lordship.
500 rupee means jointly or severally? That means together
severally,
they had to pay 500 rupees.
No, separately.
Each of them to pay 500
yeah,
rupees.
per head, my lord.
Yes.
So, in view of this particular order, my lord, an application was filed before the District Judge, my lord.
Yes.
And the matter was taken up by the Assistant to District Judge, my lord.
Okay.
And the matter, several orders has been passed, which is at page 42. And the next date is fixed on 26/4 of 2024.
Okay.
So, my lord, when the matter was still pending, my lord,
Yes.
the respondents, they approached the CEM respondent number 2, my lord, and the respondent number 2 again going against its own order, passed, they took cognizance.
What kind of order he passed? Where is that?
Page 43, my lord.
Seen the Prohibitions and Restrictions? Order 9 Rule 13?
Yeah, that is what, my lord. Now he's going against his own order, my lord. He has already forwarded the matter.
It's not the court that passed the order also. Anyway, yes, yes.
So my grievance before this honourable court, my lord.
Where's Mr. D?
Your Lordship, I'll accept the notice, Your Lordship, and I'll obtain instruction.
Where's Mr. D?
He's having some difficulties, Your Lordship.
You have difficulty?
Personal difficulties.
Okay, heard Mr. E.G. movement. Issue notice. Ms. N. Raji, learned Counsel Vice, Mr. S.D. is present, accept notice on behalf of?
1 and 2, Your Lordship.
On behalf of respondents 1 and 2.
2.
Notice to issue to the remaining respondents by the AD within 3 days. Stop. You have a missed case also?
Yes, my lord.
Yes, list after 3 weeks for instructions, affidavit, and for first report, for first report on the other respondents. I missed case. Oh, sorry. Yes, Miss case number 53, 2024, interruption number 11 of 2024. Stop. This application is has been filed by the petitioner praying for stay of the impugn order dated 18/3/2024, passed by the respondent number 2, chief elected member. In what is the number of the case?
No number, my lord. No number. They just pass an order, my lord. Simply.
Mr. E.G. Movement, the counsel with the petitioner submitted that. The petitioners submitted that the respondent number 2, chief executive member, while the matter has already been seized by the
assistant judge, my lord.
District Council Court, West Garo Hills, Tura, with regard to execution of decree passed by the village code, and also confirmed by the respondent number 2, has taken up the matter again on an application of the respondents and has admitted?
Lordship admitted, my lord.
The disposed of matter for reconsideration. Therefore, praise that in the interim, as the matter is already fixed before the assistant judge on 23rd of?
It's the 26/4, my lord.
26/4/2024. That some interim direction be passed to keep the proceedings before the respondent to an abeyance. You have anything to say?
Your Lordship, for the interim, Your Lordship, let this, because the matter will be fixed next week, Your Lordship. So let the interim.
Not next week, 3 weeks.
Yes.
Yes.
So the interim order let not be given, Your Lordship.
Ms. N. Raji, by the SCT, has submits that at this stage, perhaps interim order might be passed out hearing all the respondents.
Yes.
So she prays that notice be issued on interim prayer for consideration. So, next paragraph, having heard learned counsel for the parties examined, it appears a prima facie case has been established in favor of the petitioner for some interim orders at this stage. Accordingly, the order dated
18/3/2024.
18/3/2024, passed by the respondent number 2, which is annexed at annexure to the writ petition.
8, my lord.
Annexure 8, bracket annexure 8 to the writ petition is stayed until the next date. Yes, this for 3 weeks, together with the main case.
Hello, my lord.
Daily list item number 1.
Mr. Depp is hiding there and you're making you appear. Very good. Yeah. Like a tag team. Yes. Is a condemnation matter?
Yes, Your Lordship.
How many days? How many days delay?
1,512 days.
Are you ready with the matter? Are you ready with the matter? Then you tell the court. You just
I'm not aware of this.
Yes?
I'm not aware of this matter, Your Lordship. I apologize.
You're not aware of this matter? Yes, sir.
Next week, Your Lordship.
Who's leading in the case?
Mr. P. Yubin.
He didn't give any instructions.
No, Your Lordship.
You not look at the
Since
file
he's
also?
out of station.
I mentioned been made on behalf of Yubin, counsel response out of station. Accordingly, this is a matter of the 1 week case.
Item number 2. Mr. Pradhan, this is matter. Why is a letter been sent to the Joint Registrar by this PN Accounts Officer, Assam Rifles?
Lordship, initially we were not aware, Lordship, that this letter has been sent to the Joint
You
Register.
just instruct them.
Yes, Lordship.
Instruct them that they should not send letters to
Yes,
the court
Lordship.
directly for substitution.
I apologize, Lordship.
You told them. Is any officer Assam Rifles present here?
Lordship, they are outside. Lordship, can I call?
List it next week. Let Dr. Mozega come.
Highly obliged.
Item number 3.
Any submission has to come to the councils.
Yes,
If the wrong person is pleaded, you have to tell the court that maybe this Mr. A instead of Mr. A, Mr. B should be there. Not that you write to the court that please substitute so and so.
I apologize, Lordship.
Item number
He'll
3.
have to appear in court. He'll be followed up for contempt also. Yes. Yes.
Your Lordship, I briefed sometime this matter, Your Lordship. I have
Why?
instructions from the petitioner, Your Lordship. We haven't received any instructions from the petitioner as of yet, Your Lordship. Because there's an affidavit
No,
that we
only thing
filed
is
on the
that
3rd.
was there any delay in your submission of the VAT deduction certificate?
That's the thing, Your
Was
Lordship.
there delay or not?
We have to seek instructions on that matter, Your Lordship.
This matter came up on 3rd of April. You supposed that's why this. Last time they appeared in person and apprised the court as to why the delay in payment. And in fact, it said that excess amount has been given to you.
Your Lordship,
You have no instructions.
No instructions, Your Lordship.
You want to dismiss the case?
No, Your Lordship.
They can come restore it. They'll come very fast.
Next day,
With
Your Lordship,
instructions to you.
I'll come with instructions.
Yes?
And the next day, I'll come with instructions, Your Lordship.
As well dismiss for default.
No, Your Lordship, I'll come
Then?
with instructions.
Okay, Mr. Hansford prays for allowed further 1 week's time to obtain instructions. List that after also.
Obliged, Your Lordship.
Highly obliged.
My Lord, this matter on the last occasion had sought time to file my rejoinder. However, upon going through the counter, my Lord, I'm not able to comprehend what exactly is the stand of the state government. Because the case is fairly simple. If your Lordships kindly have my writ petition. Now, my appointment is at page 13, my Lord, annexure 1.
13.
Yes, my Lord. Page 13, typed copy is at page 14. Now, these are district...
One second.
Yes, my Lord.
On recommendation of the selection committee, incumbent are hereby appointed library assistant, LDA cum typist. You are which number?
My Lord, I am at B, number 4. Now, these are district ministerial post, my Lord, the post of peon. Now, at that point in time, my Lord, in 2000, this was issued in 2000, there was an advertisement, my Lord, by the Departmental Selection Committee. I applied. I took part in the selection process. I stood successful, my Lord, and this order has been passed by the director, my Lord, which your Lordships will find at page 15. Directorate of Education, Research and Training. So, my Lord, if I read this order, it says, on recommendation of the selection committee, the incumbent are hereby appointed temporarily as so-and-so, in different scale of pay as noted below, against post created under so-and-so. So, it's against vacant post.
Yes.
Now, my Lord, subsequently, a letter was issued at page 16, annexure 2. This is 2016. I was appointed in the year 2000. Now it says, my Lord, this is dated 22nd of July 2016. This letter was addressed by the Deputy Secretary to the Under Secretary of the Personal Department from the Education Department. In this particular letter, they state, my Lord, that in inviting reference to the letters indicated above, I am directed to say that the office staff under Diet, so-and-so, have been appointed by the Departmental Selection Committee and not by the District Selection Committee. Not by the District Selection Committee. Now, my Lord, I state in my petition at page 17 that my Lord, the Meghalaya Ministerial District Establishment rules came into effect only in 2017. There was no rules prescribed, my Lord. And prior to that, my Lord, at page 23, this is the Assam Ministerial District Establishment rules. These were applicable, and these rules do not deal with the post of grade 4, my Lord. Therefore, my Lord, if your Lordships kindly have page 41.
One second. This is 67 rules. Now, it doesn't deal grade 4 posts.
No, my Lord.
Where
it deals, my Lord, only with, if your Lordships have page 25, my Lord, at recruitment.
Yes.
Rule 6. Rule 6.2, my Lord, Rule 6.1 deals with Saristadar, Sadar Assistant, and Subdivisional Assistant, Upper Division,
Subdivisional,
Lower Division.
Okay. LDA.
Yes,
LDA is your 6.
Yes, my Lord. LDA is 6. So, my Lord, grade 4 posts regarding peons, chowkidars and all, was not there, my Lord. Now, my Lord, at page 41, this is the latest letter which is issued by the principal to the director, my Lord, for regularization of these posts, my Lord. And at the next page, page 42, your Lordships will find me at serial number 2. Appointed in the year 2000, my Lord. Page 42, serial number 2, Mausyang Dhar, peon, without break. Whether with break or without break. Whether daily wages or contractual, not applicable. The pay scale, my Lord, against post so-and-so. Now, my Lord, they have filed an affidavit, my Lord. If your Lordships kindly have the affidavit filed by the state.
One second. Let me see your prayer.
So,
your initial appointment was in which year?
2000, my Lord.
2000, no, that by the district section or the department permission?
2000.
2000.
Yes, my Lord. And continuing without break, my Lord. Now, my Lord, they file an affidavit, my Lord. Kindly have page 2, paragraph 6. They say many things but don't say anything, my Lord.
Yes.
Paragraph 6, my Lord, they say with regard to the averments made at paragraph 3 of the writ petition, the answering deponent states that the procedure to be followed for confirmation of officers, staff against permanent posts is laid down in memorandum dated 25th April 1985. It is stated that one of the conditions that is required to be satisfied that such confirmation is subject to vacancy in the permanent post. Now, are they trying to say that, my Lord, that I have to be confirmed under this notification, my Lord?
Where's the memorandum? What's this?
Lord, kindly have page 7. Page 7. This has been annexed by them, my Lord.
Yes.
If I may read, my Lord.
Confirmation is not regularization.
Correct,
Confirmation
my
is a
lord.
different thing.
Correct, my lord. So this has...
Mr. Shulai, confirmation is a different aspect altogether of service.
Lordship, if you can have this matter on some other day, Lordship.
Confirmation is totally different. You are talking regularization and confirmations.
Lordship, I'm praying that if the matter can be taken up on some other day, Lordship.
No, it's just that the council is drawing attention to the affidavit, which is not, is
Yes,
neither
Your
here
Lordship,
nor
we have
there.
filed the affidavit,
That's
Your
all.
Lordship.
The affidavit has been filed, but it does not shed any light on the case. That is what he's trying to make. Not that we're hearing the matter today. Yes, with Indi Shulai, please that the matter be.
And next
this is for hearing.
Let it come for admission hearing also.
Let it come for hearing, my lord. If need be, then I will file my rejoinder. Whatever submissions flows.
Yes, Mr. Philemon Nombri submits that no rejoinder be necessary at this stage to the affidavit filed by the respondents. Accordingly, this is a matter for hearing on so and so. Yes.
Lordship, oblige, Your Lordship.
Item number 5.
Lordship, here the respondents are supposed to file the affidavit, Lordship.
Lordship, the affidavit is in the process of filing. Already served the petitioner's report.
In the course of the day. In the course of the day, filing. You also on the course of the day.
I filed, Your Lordship.
You already filed.
Yes,
they already filed?
Yes, Your Lordship.
But we have not received, Lordship.
Then?
I think she has not get the proper instruction from his senior. It was personally received by his senior petition, Your Lordship.
1 to 4 not yet been filed?
Yes, Lordship.
What are you talking about?
I have already filed, Your Lordship.
There's no affidavit here.
And I have filed since the last 1 week back.
There's one number 5 only.
Yes, Lordship.
So number 5 is whom?
It's a state respondent, Your Lordship.
You are for 1 to 4?
1 to 5, yes.
Who's 1 to 5?
I'm for 1 to 5, and the affidavit has been filed by
I
the
don't know, officer.
Yes,
Only by one number 5.
Yes, Your Lordship.
Yep. Passas paying for whom?
For 6,
6. That means this will suffice for all the respondents.
Yes, Your Lordship.
Yes, Mr. H. Abraham submits that the affidavit filed on respondents on her file will suffice for all the other respondents also. Stop. Next paragraph, MS Ipasa submits that the affidavit on behalf of respondents will be filed in the course of the day. Want to file a joinder?
Yes, Lordship.
Yes, and so and so. Please that we're allowed to file a joinder, they said affidavits. Just after 2 weeks. Yes.
Item number 6.
State they are yet to file a counter, my lord.
May it please Your Lordship. Lordship, in fact, we have the instruction, but the instruction are not complete, Your Lordship, because the officer dealing with all these cases is on election duty. If Lordship is kindly allowed us some more time, Your Lordship.
Lordship, I'll be filing my affidavit in course of the day, Lordship.
Very good. Mr. Inishulai, then EG, praise it without some accommodation. Also praise without weeks for the time.
Let it be 2 weeks, Your Lordship.
Praise Ramti submits that on behalf of respondents 3 and 4, the affidavit be filed in the course of the day.
Lordship, similar. I have a similar prayer, Your Lordship, in the next item
Lordship,
also.
we have filed our miss case also, Lordship, in the last occasion.
For?
For vacating the stay
This one?
order, Lordship.
No, my lord. In this matter, the respondent number 3 and 4, they have filed a counter affidavit. However, earlier we have filed also the additional affidavit to bring on record regarding the withdrawal of that mid scheme, which
So
they are playing.
what affidavit you will file now in the course of the
They
day?
are
The affidavit
the
with
show cause to
respect
the affidavit which you filed.
Yes, Lordship. The reply to the additional affidavit.
So you
which
already
they-
filed affidavit earlier on?
Earlier we have
Only
filed for
41 on
respondent
record?
number 4, Lordship. For respondent number 4 in WPC number 13, Lordship. Number 3
one
and 4.
second. There are 2 repetitions?
2
Lordship,
repetitions.
Lordship.
This is item number 6 and 7.
And for
Okay.
for item
Okay,
number
1 second.
for WPC.
Now you file after being record saving bank account, 10/4/24, year number 4.
Lordship.
You file affidavit, right?
3 and 4, Lordship.
No, for number 4 you file 10. Then CMD you file for 3 also, 2 affidavits.
2 affidavit, Lordship.
Yes. Now what happened after that?
Before filing of their affidavits, we have filed 1 additional affidavit to bring on record the withdrawal of the mid scheme.
It's not here.
If already filed, my
Not
lord.
here. You file an next petition.
No. In this WPC number 13, my lord.
We have a copy.
affidavit to bring on record.
I don't bring a record savings bank account.
Yes, my lord.
So to this one, you're filing a reply.
Yes,
I'll
to
be
this
filing
one.
in course of the day, Lordship, for that.
Take out an additional affidavit.
Okay, after to bring on record the saving bank account, statement Nong Dom Sandrang LP School, maintain
Whereby during the pendency of this matter also, my lord, they have withdrawn another 31,000 from the account.
Oh, you got serious allegations against 3 and 4.
Yes.
That means.
Earlier they have withdrawn 1.5 lakhs, now 31,000.
Ms. Anshulai, on behalf of the respondents number,
Lordship, for the
1 and 2.
1 and 2, my lord.
Days that be allowed further 2 weeks' time
Lordship.
to file the affidavit of position. Stop. Mr. T. Takhar submits that though affidavits in the minute petition have been filed both on behalf of respondents 3 and 4, an additional affidavit will be filed in the course of the day in reply to the affidavit filed by the petitioner, bring on record a savings bank account statement. Praise Allah. This is the matter after
2 weeks, Your Lordship.
What miscase you have in the next case?
We have in the next case, Lordship. We have to file on this case. And they have also filed their reply, Lordship, that miscase.
So you're going to take out the miscase now?
So, Lordship, the matter may come up next week, Lordship, then we can take up
The one's only gone after 2 weeks.
Let it come after 2 weeks, Your Lordship. Everything
Because the matter also, this is matter together
Number
with
3 also is yet to file the counter here, my lord.
who?
The
The other
respondent-
file counter here.
Lordship, I'll be filing today, Lordship.
Here also.
And the state respondent also yet.
You also 2 weeks. Same thing.
2 weeks, Your Lordship.
Initially, Mr. Initially, AG, please be allowed further 2 weeks' time to file affidavit. Mr. Dakhar submits that on behalf of respondent 3 and 4, the affidavit will be filed in the course of the day. Stop. Then next, miscase 43, so and so. This is matter together with after 2 weeks. Yes, for
Lordship.
consideration in the miscase.
Highly obliged.
Item number 8.
May it please Your Lordship. Your Lordship, I'm to file the rejoinder affidavit here, but then we are yet to receive the RTI from Negrims, Your Lordship, because there are some documents we have to substantiate in order to file the rejoinder.
We'll have to take also because why was it not kept vacant?
Your Lordship, in the affidavit, they have stated that the council has not informed Negrims.
When do you want it? Let Dr. Mosika be here. Yes.
After one
Actually, Your Lordship, because after they have filed this, we had filed a second RTI, Your Lordship. So we'll require time because 30 days, the first RTI also we have not received the reply yet.
Will it after 1 week? After 2 weeks?
2 weeks, Your Lordship.
Yes, MSPS normally pays that as he is still awaiting some instructions, the matter may be listed after 2 weeks. Prayers allowed, just after 2 weeks, yes.
Highly obliged, Lordship.
Item number 9.
Lordship, I am praying for some more time, Lordship, to file affidavit in this matter.
Yes, MSA Pradhan prays also, prays for further 2 weeks time to file affidavit, yes. Yes, thereafter also.
Item number 10.
Lordship, I have a similar prayer, Lordship, in this matter.
For affidavit?
Yes, Lordship.
Enjoy. For 2 weeks, yes.
11.
Someone pray also?
Yes, Lordship.
Please, Lordship, I appear in item number 11. They were to take instructions.
Yes, what's the matter about?
Please,
What's the
Lordship,
matter
this is
about?
that case. Please, Lordship, this is that case where I was disqualified for appointment on the ground of malfunctioning of teeth.
Dental issue, Lordship.
What a teeth?
Dental issue.
Yes, dental issue.
Since the DHI will have it next week.
Yes,
for instruction list
Right.
after 1 week. Yes, as the DHI, Dr. N. Mosika says it's not present in court, will listen matter to 1 week. So expected next day they come forth with instructions.
Highly obliged, Lordship.
12.
Lordship, I pray for 2 weeks' time to file affidavit
You're praying for whom?
For the respondent number 1.
Negrims? Oh no.
Prudent.
What's prudent EPC?
Prudent.
1 week.
2 weeks time, Your Lordship.
What is your name?
RM Shadab.
Shut up.
RM Shadab.
2 weeks.
Yes, Lordship.
Mr. Nath, you file. It's so for respondent 1 and Mr. Echanat for 2 pray for not further 2 weeks time to file affidavit. This thereafter also.
Much
Highly
obliged,
obliged,
Your Lordship.
Hearing supplementary list item number 2.
So, what are your instructions?
Your Lordship, as per the instructions received, the water is insufficient and very irregular.
That's not the concern of the court. The only concern of the court is whether there is an alternate water supply that, that the bore will not be required any further. Because since last year, the only thing that they said that, look, we will not give you permission because there's a PHE, what do you call it?
GGF. Borewell.
Borewell that's going to be operated, implemented. It's being implemented now. So, what will we do with petition? You file complaint against them for insufficient supply of water. Sure, yeah. We'll close it now, yes. According to order.
Actually, for the application for drilling water, so the petitioner has made since 2017, Your Lordship.
Yes, we are aware.
It wasn't considered back then.
Suchang Cottage.
Yes, Your Lordship. She was forced to make another
See,
application.
Now, your name, is Suchang Cottage, your cottage. What's the name of your house?
It's just a residence, Your Honor.
No. What is your house have any name? They have annexed a picture of Suchang Cottage showing some connection going into this house. Is this your house?
This is the
Is the house?
Yes.
Okay, then yes. The petitioner being aggrieved with the non-grant of permission on her application dated 2017, for drilling of a borewell is before this court by way of the instant writ petition. Stop. The materials as placed indicates that the permission of petition was rejected by letter dated 13 Annexure 8 13/10/2022 Annex 8 to writ petition on the ground that there was a presence of one PHED. The presence of a drilling, there was a presence of a PHE borewell at a distance of 100 meters approximately.
Actually, even that also is wrong, Your Lordship. It's actually 500.
Okay, at a distance of 100, okay, at some distance from the proposed site of the borewell of the writ petitioner. Stop. In the writ petition itself, the photographs had been annexed to show that the PHED borewell as on November 2022 was still non-functional. Stop. Annex photographs. For photographs, annex. Oh, sorry. No photographs. No. interpretation itself at Annexure 9. Yes. Stop. The Learned Government Council at that point of time had submitted that the PhD borel was part of an ongoing scheme, and the moment that the power connection was given by the MECL, the same would be
functional.
And water supply would be provided to all the residents of the area. Stop. Next paragraph. Today, Mr. H. Abraham, Learned Counsel for the Learned GA, has produced photographs that the borewell, which is a component, of the ongoing scheme, namely Nongra Water Supply Scheme Phase 1, has been commissioned and is providing functional household tap water connection to all residents of Nongra village under the Jal Jeevan Mission (JJM) scheme. A photograph has also been produced showing the connection being provided to the writ petitioner's residence, namely Suchang Cottage. He therefore praised that as the submits that as the PhD borewell has since been commissioned, the need for a private borewell for the petitioner no longer exists. He praised that the matter may be closed on the basis of his submissions. Next paragraph. Ms. S. Sinkram. G. Sinkram, sorry. Learned Counsel for the petitioner, though not denying the fact that the said borewell has been commissioned recently, however, has submitted that the supply is absolutely insufficient
and irregular.
And apart from being irregular, he submits that, he praised that, he submits that the necessity for the borewell still exists, and that orders be passed to allow him to do what? No, it still exists. So, next part. I've heard that council parties examine the materials, especially the photographs which have not been disputed, which have been produced, especially photographs produced by the learned GA. As on 22/3/24 about the commissioning of the borewell. In this view of the matter, this court deems it fit to close this matter at this stage. However, giving liberty to the writ petitioner to further agitate, or leaving liberty to further agitate. I want to give it to the petitioner to further pursue the matter with the authorities with regard to insufficiency and irregular supply of the water from the borewell. So, with the above, accordingly, matter stands closed and disposed of. Copies of the photograph dated 22/3/24 are taken on board and made part of the record. You file again with the authorities. Yes.
Daily list item 15.
Your Lordship, I'm afraid this matter may come after some time, as the senior counsel is on legs. He's engaged in one matter in courtroom number 4.
What's the matter about?
regarding managing committee matter.
And the committee matter?
Challenge the constitution of the managing committee.
Is it still alive or since expired?
Mr. Sheikh is the council, my lord.
Where was the Sheikh?
He just left, my lord.
Left where? For whom?
No, my lord, he went to Garo Hills.
So, I request the council for the I should request Mr. S.K. Hassan via Mr. S.K. Sheikh. This is matter after?
After 2 weeks, my lord.
After 2 weeks. 2 weeks, all right. What is urgency?
Deeply obliged.
Yes.
19.
It is for compassionate appointment of the central government.
19? Yes,
Yes.
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 Who's arguing? Mr. Pandit, Mr. Nyota, Mr. Siddiqui? Who's arguing?
Sir,
I'm arguing.
Sir will lead you.
Okay, you argue. Okay. Yes. Yes. Yes.
My lord, the competition was made by the committee in my favor that I am the most appropriate candidate to be appointed as on the compensatory ground, my lord. But despite that, the same was not considered by the officer and it was rejected by the Deputy General Accountant General. Whereas as per law, once a committee has submitted a report or recommend the name of the petitioner,
In the additional affidavit, in their affidavit, Your Lordship.
Page 36, Your Lordship.
Page 36.
Yes, there is additional affidavit.
No, Your Lordship, main affidavit, first affidavit. Page 36.
36 says?
The findings of the
This is a proceeding of the screening committee, Lordship.
Departmental screening committee.
Okay. Where's the conclusion?
relevant portion is in paragraph 8, page 37.
The screening committee.
Yes, Your Lordship.
Yes. As
per the welfare officer report, the eldest son of Sri Deepak Kumar Joshi after marriage has left the family and has no connection with the family. The welfare officer report also states that the other son, Sri Krishan Joshi, is employed as a field assistant in a special bureau, government in India, but does not support the family financially. The report further states that the mother of late Sri Kedarnath Joshi is also a dependent. The committee was informed that the Office of Principal Accountant General Audit Meghalaya Shillong wrote to the Office of the Commissioner Special Bureau Shillong wide letter number such and such dated 6/11/2017 to ascertain the list of dependents of the concerned son, that is Kishan Joshi. The Office of Commissioner Special Bureau Shillong intimated by letter such and such dated 7/11/2017 that as per their records, Sri Kishan Joshi, son of late Kedarnath Joshi, who is working as field assistant has no dependents. The welfare officer also reported that the only source of income is the family pension and that the family has no immovable property. The welfare officer further reported that financial condition of the family is very bad with hand-to-mouth existing.
Okay, what is the, what do you call it, what is the sanctity of this screening committee? Are you bound to accept it?
Lordship, whatever the finding of the DSC, the Departmental Screening Committee, we have recommended her. Because we found her eligible.
Yeah,
No
then
doubt
what happened?
about it, we found her eligible. We also gave her, Lordship, if you come to page 38 at para 12, we allotted her 95 marks, which is one of the highest. But then what has happened is, like, when we forwarded this matter to the headquarters Delhi, then this letter, Lordship, kindly come to page number 35.
Of the affidavit?
Yeah, of my affidavit.
Yes.
I am to refer to your letter dated letter number so and so and so, requesting therewith appointment of so and so as MTS on compassionate ground by relaxing the norms where there is an earning member in the family. We have written to them, Lordship, stating that relax the norms.
The screening committee sat when?
This one, numerous occasions, Lordship. 2017, 18.
This sat in 18. I mean, this sat on?
2017, 18,
this
Lordship.
recommendation committee last is 17, but this letter 16, 35.
Yes, this is 16.
16, sorry.
Yes.
Yes. What relation will it have then?
No, because the one they are challenging.
This one is already done. I mean,
because the same,
after this letter was issued, the screening committee sat. Yes. So what relevance will it have?
So the same thing, Your Lordship, here the impugn order which they have.
That March 2018.
Yes, Your Lordship.
This is from your office.
Yes, Your Lordship.
Then, how are you saying that? See page 47, Annexure 9A. Correct? Mr. Pandit?
Yes, Your Lordship. 46. Page 9.
See?
Annexure 9.
The same grounds, Your Lordship.
Where's the letter of headquarters then? You read this letter.
This is the letter. I am to inform you that as per direction of the Honorable High Court Meghalaya, dated such and such, your application for compensation appointment has
I'm telling Mr. Karmaplan.
Oh, yes.
Read para 3 of the impugn.
However, as there is an earning member in the family and your family is entitled to receive family pension at the enhanced rate till 11/02/24, and there are no liabilities in the family, the competent authority in headquarters office has not accorded approval.
Where's this letter of headquarters? Where is it? This 18 letter, you can't refer to 16 letter because after 16, the screening committee sat and found it eligible, notwithstanding the fact that there was an earning member.
That's what, Your Lordship. They have come.
Where's the letter? That number 3, you base this number 3 order of your letter. You basing on what? Was the screening committee report ever forwarded to headquarters?
Actually, we forwarded, Your Lordship, but then
this is just a slipshod kind of reply to the. Get the letter, Mr. Karmaplan.
Yes, Lordship, then I'll take instruction for that, Lordship.
In the course of hearing on examination of the impugn order, impugn order dated, impugn letter dated 28 March 2018, at para 3 of the letter, reference has been made to a letter of the headquarters for disallowing for non-grant of appointment compassionate ground. Stop. The said letter referred to that find place in any of the materials placed before this court. Stop. Counsel to obtain instructions and produce this letter on the next date. Just after 2 weeks. Otherwise, there's no letter.
I'll
the
find.
16, the 16's gone.
I'll take
Water
instruction
under
on
the
that.
bridge, yes.
Oblige, Your Lordship.
22.
Yes.
22.
Please. Your Lordship, here, Your Lordship, the prisoner being aggrieved by the non-payment of salary, Your Lordship, and
See, you file affidavit.
yes, Your Lordship.
What do you see in the affidavit?
It says that. Can you come to page 10, Your Lordship, in my affidavit?
The additional affidavit?
Yes, Your Lordship.
Where is that court notification issued by the government? Page 10 of the second affidavit?
Yes, yes.
Of your, sorry,
Yes.
of your bring on record affidavit?
Yes, Your Lordship.
Yeah. Okay, start, please. What's the matter about?
Being aggrieved by the non-payment of salary, Your Lordship, and her regularization, the prisoner has approached this way. The prisoner
working
has,
as?
Working as a orderly peon, Your Lordship, under the respondent number 3, Your Lordship. She joined in the office in 2009, Your Lordship. And the prisoner has been allowed to draw all the payment and allowances and also the annual increment, Your Lordship, which are admissible from time to time. And also, Your Lordship, she has been enjoying the benefit of fifth pay commission, Your Lordship. And in the year 2023, Your Lordship, she was all sent for polling of election, Your Lordship. But suddenly, what letter?
Where's the appointment letter?
Appointment letter, and show one, Your Lordship.
Page 16, Lordship.
Page?
15.
15.
Type copy is at the 16, Lordship.
1, 5, okay.
She joined in 2000.
This is in
2009, Your Lordship.
2009 you joined?
Yes, Your Lordship. And she has been discharging her duties, Your Lordship, till now, Your Lordship. But in
2009 you appointed, okay, in the
and from time to time, Your Lordship, I have been allowed to for annual increment, Your Lordship.
3 months, okay. July. Then what happened?
Then, Your Lordship, in 2022, Your Lordship, November, my salary was withheld, Your Lordship. And then again.
You're still working now?
Yes, till now, Your Lordship, I'm still working.
Lordship, based on the Lordship's interim order dated, I think, dated April or May last year, Lordship, she's still, although she's not working under any sanction post, Lordship.
Why are you given increment? You're just temporary worker.
Lordship, as per the, I'm not aware about this, Lordship. I think so must be because of the fundamental rules and.
I've been enjoying all the benefit, Your Lordship, of employees.
Enjoying benefits different. You might have enjoyed them wrongly, but not cloak you with vested right. Where's the impugn order? Nothing. It's just that they stopped paying you. From when?
From 2022, Your Lordship, December, November. And Your Lordship, in 2023, Your Lordship, the respondent number 3 issued a letter, Your Lordship, which is in page 70, Your Lordship. Issued a letter stating that because my service is not yet a regularization, that would help my
17?
salary. Yes, Your
Page 17 petition?
70. 70. 70.
Okay. So what do you want it petition? Only to get your salary?
Now, Your Lordship, we actually.
Are you continuing in service now?
Yes, till now, Your Lordship, yes. Till now, I am in service, Your Lordship. But my service till now have not yet been paid, Your Lordship. But with regard to the regularization slip, just recently the government has passed notification stating that those who appointed after 2009, Your Lordship, will be examined. and status quo may be maintained, Your Lordship.
No, correct. But I'm saying that now, presently, while you're standing here, as on date, what is your grievance? I've been not
My
being
salary,
paid
Your Lordship.
salary.
Yes, Your Lordship.
I've been paid now or not?
No, not yet, Your Lordship. And regarding with it, I
Not
have
yet,
filed my
but
miscase,
you're
Your Lordship.
discharging your duties temporarily.
Yes, Your Lordship.
Yes.
I have filed my miscase, Your Lordship, for release of my salary.
Is
Your
she
Lordship.
working?
Yes, Your Lordship.
Lordship, as per the Lordship's interim order, Lordship, she's still.
She's working.
Lordship.
Yes.
Then why not paying her if you're using her services, not going into the aspect of regularization or anything else or whatever entitlement?
Lordship,
but if she's been appointed temporary 2009, if she continues, then you pay her.
Lordship, I'll just bring out some facts, Lordship.
Okay, let's see. What do you have to say?
Lordship, shall the petition? Lordship.
Bring out the
so
fact. What fact do you want to bring out?
Fact is that, Lordship, the petitioner has been working on an ad hoc basis since 2009 as a orderly PO, Lordship.
Yeah.
This post was actually held by one person, Durga, one other person, Lordship, and she was also temporarily promoted to post of LDA, Lordship. Upon a promotion to the post of LDA, then the petitioner here was.
Now you mean to say that there was another person who was temporarily appointed to this post, has been promoted to the higher post?
Or temporarily promoted to LDA, Lordship.
Without regularization?
Lordship, temporarily, Lordship.
No, temporarily, see, you can't be promoted if you're having a temporary post. Suppose it has been regularized or confirmed in one post, how can be considered promotion?
Lordship, that
this was happened here.
Lordship.
You mean to say there's a post oddly peon was occupied by some person?
Lordship.
That person also was not regularized.
Lordship.
Still on temporary basis.
Lordship.
That person is given promotion.
Lordship. Then why the 2020 Lordship?
Why
but then
2000
Lordship, by 2022 Lordship, where the
cabinet regularized.
Yes, Lordship.
That
The
other
cabinet
person
decision was
regularized.
taken. Then this person Durga was regularized to her original post, which is orderly PO, Lordship, and so on and so forth. Whatever persons who have been temporarily promoted
so after
also.
he was regularized to the post already peon, that means what happened? He's like this.
So there was no more posts. There was no more
post
posts
to accommodate her.
Yes, Lordship. Hence, they stopped
But
paying
why
her
did
salary.
you promote this person in the first place to LDA? LDA?
Lordship, the post was Durga Sumer. She was yes.
It's right. She has no claim to the post, but it's strange the way you've gone about it. I understand she can work only against a sanctioned post temporarily, and that sanctioned post now, after realization of the whoever the other lady is, into the oddly peon post.
Lordship, paragraph 6 of my counter, Lordship, is clear that
six where?
of my counter affidavit, Lordship, at page number 5. Lordship, may I read? In reply to the contents of paragraph 21, with regards to a letter dated 01/02/2023, whereby the respondent number 3 had asked the Deputy Commissioner, District Election Commissioner, to examine the petitioner on the grounds that she is not a regular employee and that her salary has not been withheld for the last 2 months. The answering respondent states that the petitioner was appointed to the post of orderly peon on an ad hoc basis since the post was lying vacant upon promotion of Srimati Durga Somer to the post of LDA. It's further submitted that Durga.
So now you appoint her temporarily against the post of LDA. That post becomes vacant now, a sanctioned post. Well, how do you promote a person like this?
Lordship, as per my understanding.
You know that settled law means what? If you give promotion to a person,
Lordship,
right? Can you revert that person back to original to the lower post? Anyway, and regularize, what do you call it, retrospectively, whatever. Strange, yes. There's no question of promotion in the first place.
Lordship.
Or temporary. What is being done, Mr. Shlai? And it creates just, it creates, this person has been appointed now out on the cold because some person's, smart person has given promotion to her.
And then it creates problems also. It happens.
What relief will they get then? Yes. So you consider her for ad hoc appointment to some other post?
Lordship, that will also be a problem since the appointments of ad hoc appointments have been banned according to the order.
The ban is just on paper. It's being done rampantly. Number one, what's happened here is that you appointed this petitioner temporarily against a post. You give you allowed regular pay, but you increments also. You treated her in all respects as a regular appointee against that post of orderly peon.
Lordship.
And even for the other person also, you must have treated her as a regular employee, even though she was the same status, given her promotion to the post of LDA. So that's what I'm saying. Now, appoint her against that LDA post on promotion since she served 2009. You did the same thing to the other person. Of course, that can't be done just in jest. Where's the letter you showed regarding that status quo in your...
In my affidavit, Your Lordship, which is in page 10.
Very difficult.
Maybe, Lordship.
Have you seen this annexure, page 10? What do you have to
Yes,
say about
Lordship.
this?
We had to receive instructions with this.
What do you have to say on this page 10? I mean, page 10 thing that
Lordship,
they should be
yet to
now
receive-
whatever rightly or wrongly upon ad hoc.
Lordship.
But if this order of the government is to be complied with, status quo will maintain it for all its appointees on a basis prior to issue this order.
Maybe, Lordship, as per my understanding, Lordship, these maybe status quo will be applicable only to these ad hoc employees who have been working, who have not been regularized, but then are working on sanction posts.
Prior to issue of the order.
Maybe they were for all this. Maybe they're applicable to the ad hoc employees who are working
can't go on assumption.
on sanction posts, Lordship. Because Lordship, if I can take Lordship to, the letter dated 23rd June 2022, Lordship, page number 11 of my affidavit. The conditions, one of the conditions for regularization of those persons before appointed on an ad hoc basis before 2007, Lordship, would be that they should have been working on against sanction posts only, Lordship, at page number 13, Lordship.
She was appointed as a sanction post.
But then as per...
Now what injustice has been done to this person? See?
Lordship.
By whose action? By action of your department. Because you have promoted some person and that sanction post was vacant. She was appointed 2009 against that post.
Lordship.
Then?
But then, Lordship,
one fine day.
Respectfully, Lordship, if she, upon her appointment, Lordship, she was also given on caveat, Lordship, since 2009, subject to discharge with our signing.
That has no meaning. That has no meaning, Mr. Karwanla. We have to balance equities, not look into the fine print.
Lordship.
Then?
And Lordship, and even in some other cases also where Lordship, where ad hoc employees were terminated, Lordship, this Honourable Court, along with the Honourable Apex Court, Lordship, has held that the ad hoc employees will be having no rights.
No rights, of course, but in the case of this person, it's a very unique case. Like this court saying it to balance the equities now, what relief will be entitled to? It's a court of equity. Now this person has been appointed by you against a sanctioned post. Is there a question? He's an outsider, just appointed like that temporarily. Then they can go. And whether that latest letter applied to this person or not. Because when at the date of appointment there was a sanctioned post as vacant. Now after regularization of the other lady, that sanctioned post has gone because she's been regularized against that sanctioned post.
Lordship. Lordship, if I can...
Tough case, Mr. Señor. What are you going to do? You can't just take shelter of that appointment order says that it can be terminated without discharge, without notice. After 3 months, yes.
If I can take your lordships to the order passed by this honorable court lordship in
by this court
or by Justice Moria lordship.
Let's see. They don't have a case, but then a case you have vested them with some kind of right.
Can I take your lordships to paragraph 22 lordship?
This is the teacher's case.
Lordship.
Para
22 lordship. Internal page number 13 lordship. May I read?
Yes.
In regards to the petitioner's prayer regarding regularization, reference must be made to the decision of the Apex Court in State of Karnataka versus Umar Devi, 2006 4 SEC 1, and essentially the observations made in paragraph 15, 16, and 53, which reads as follows. Even as the threshold...
We don't need to go here.
Lordship. Can I take lordship to paragraph 53 of Umar Devi? Lordship is the next page.
We are aware paragraph 53.
Lordship, can I go to the emphasize a portion, Lordship? The question of
regulation. He's not asking for regularization.
Lordship, he is.
Just asking for his back salary and for...
Lordship, he is asking for regularization. Lordship, I continue your Lordship to paragraph page number 12 of the prayer, Lordship.
No, he can ask, he's not entitled to it.
Lordship. Because in this 53 of Umar Devi Lordship, it states that the question of regularization of services of such employees may have to be considered on merits in light of the principles settled by this court in cases referred to, and in light of the judgment. In that context, the Union of India state governments and their instrumentalities should take steps to regularize as a one-time measure the services of such irregularly appointed who have worked for 10 years or more in duly sanctioned posts, but not under the cover of the orders of the court or tribunals.
Right. Because that is correct. Like you can't correct a mistake in an appointment through regularization.
Yes, sir.
It can't be connected that way.
No, sir, but it says that
this case is case with regard to people who lack qualification. This case that you've brought here, right?
Lordship.
So that's the thing. So even for the post, they cannot claim if they are upon ad hoc basis, lacking qualification. Yes. Only thing they had was legitimate expectation, right?
Yes, Lordship, and legitimate expectation also, Lordship. There are orders of this court, Lordship, which is covered.
But you see, that where's that? Can you produce the what do you call it? That promotion aspect is here or not of the other lady?
Lordship, since the other lady has no promotion aspect, Lordship, I can bring.
Because you see, that has to be reflected in this order also. Though
Lordship,
this petition might not be entitled any relief, but that should be reflected. Because you cannot, promote a person regularized respectively to oppose and be thrown out. Or they have no right.
Answer, Lordship.
That should come out in the order, yes.
Lordship, I have stated in my paragraph. In my paragraph 6 of preliminary submissions, Lordship, at page number 3, Lordship. Paragraph number 6 of preliminary submissions,
yes.
page number 3, Lordship.
Mr. Nyota, what to do? You will not get any relief, but only that the manner in which the respondents have gone about this thing, that's...
Your Lordship, I have been working till now, Your Lordship, but my salary has been not yet been paid, Your Lordship.
Since when have been paid?
Since November 2022, Your Lordship.
Then you will pay you till now and that's it?
Yes.
You're still working now also?
Yes, Your Lordship. Now, I only want my salary to get paid, Your Lordship, but regarding with that, the post, Your Lordship, the government has already issued a notice, so based on that, let the government be take appropriate step, Your Lordship, for regularization. Because the thing...
He's very smart. He's taking shelter of that 5th April, or what, 224 letter.
Yes, Your Lordship.
What he's saying is that pay me now for a time of work and take a call on my continuing service by taking into account that letter. Like a chess game is done.
What
are you going to do? Is it acceptable?
Lordship, as I've stated, Lordship, there's no sanction post where the
she's serving right now.
Where she's serving right now. Lordship,
but
even the
appointed against sanction post.
Lordship, he was.
I have been working there, Your Lordship, till now, which means post is there, Your Lordship.
No, post not there any longer. By what he says, that post has evaporated.
Filled up by the original person was appointed. But the Lordship, the problem which is being faced by the department right now is under which heads will salary be
paid. We understand that. But can you pay her for the time that she's been in service since 22 till now? You take instructions, then we'll dispose it off. Then they have no claim for regularization or against the post also.
Lordship.
But the law is the law.
Lordship.
I'll not record anything, you take instructions. This matter after 1 week. Enable Mr. H. Karan Learned, additional senior advocate to obtain instructions as to whether the department will afford her a salary for the period that she served till date. But after that, they have no claim to the post. Of course, irregular has been what has been done, but it takes it back. Yes.
Right. I'll oblige.
24.
Wait, please, Your Lordship. Your Lordship, this matter is already heard on last occasion.
Heard? By whom?
By Your Lordship.
Yes.
This matter, Your Lordship, is pertaining to my reversion order, Your Lordship.
There's a judgment. Where's the judgment? There's another judgment passed a similar matter, Typist reversion after they opted for that.
Lordship, I'm
great system.
Last time I told Ms. Nombri also.
I'm not.
No, Your Lordship.
There's some judgment passed by this court, I think. I don't recollect anymore.
Lordship,
on similar grounds that once you opted for that, what's that?
Grade system.
For a grade system, then you go out from the seniority list. Correct. Mr. Chair, once you opt for the grade system,
Lordship, that is our case only.
Then you out of the seniority
you cannot
list.
approve it and reprobate, Your Lordship.
But here my case, Your Lordship, is that if Your Lordship would come to my notice calling for speed test, as per the
yes,
it's Annexure 3, page 28, Your Lordship.
Yes.
I'll just read, Your Lordship. Enclosed, please find herewith a copy of notification number so-and-so dated 5/12/2012 from Secretary Personnel so-and-so, which is self-explanatory for your necessary action. You are requested to inform the undersigned whether you intend to appear for the speed test for Typist grade 2 on or before 19/8/16,
Yes.
so that the matter may be referred to MPSC for necessary action from their end. Your Lordship, this letter notification 5/12/2012 is on the next page, Your Lordship.
Yes.
This was following as per the guidelines of the service rule, Your Lordship, where the Meghalaya Directorate Establishment Ministerial Service Rule.
Yes. Amendment Rule 11.
Amendment Rule 11, clause Rule 11, clause 2, Your Lordship. Typist grade 2. Typist with a minimum of 3 years of qualifying service in grade 3 shall be eligible for appearing the speed test of 45 words per minute to be conducted by the MPSC, and their placement in the grade shall be subject to passing the speed test. Here, Your Lordship, is very clear that their placement in that particular grade shall be subject to passing the speed test. But here, the petitioner has appeared in the speed test, but she failed, and she continued in the same grades.
No, exactly. The placement in the grade, that means when for qualifying in grade 3, shall be eligible for, you'll be placed in grade 2 only if you pass the speed test.
Passing the speed
because
test.
see, suppose you pass, you jump among many people who are already there in the gradation list, correct?
Gradation, yes.
They just been going along, they're not taking the speed test, then by by a flux of time they will be promoted, correct?
Yeah,
now by opting for this grade promotion system that by speed test, that means it is like a shortcut method on efficiency. That if you can type a certain word, then you're considered you're placed in other grade. Those people who have been serving before you also, they remain in grade 3, you don't take the speed test. Now what they're saying is that once you've opted for the grade system, whereby you go for speed test for promotion, that means after you fail, it doesn't mean that you'll be reverted back to that, you'll remain wherever you are.
Understand, Your Lordship, but they were...
Until you take next speed test. Yes.
The petitioner...
Have you challenged this notification?
Yes, Your Lordship.
It's under challenge?
Yes, Your Lordship. Because
this 5th 2012. This Amendment Rule 11.
Amendment Rule 11. Bring on record, Your Lordship.
No, have you challenged it?
Because I've challenged the office memorandum, Your Lordship, because based on the office memorandum which they have relied, my promotion has been reverted back. If Your Lordship please come to my...
Let's see that.
To the second DPC, which is at page 44, 45, Lordship. Relevant page. Where my reversion order under DPC, Your Lordship. It's fall under agenda number 3 at page 44, Your Lordship.
Where?
Page 44, annexure 12.
Yes.
Annexure 12, agenda number 3, Your Lordship.
Yes.
Promotion to rank of LDA. Vacancy 1 post. The committee, while referring to all the relevant provision in the Meghalaya Directorate Establishment Service Rule 2010, that is Rule 92, 93, and 94, observed that out of 29 sanctioned posts of LDA, as per the provision of Rule 94, the ratio of recruitment shall be 23 posts by direct recruitment, 3 posts by promotion from among the typists, and 3 posts by promotion from among the grade 4 staff of the department. As per existing provision, the vacancy is to be filled up is from the quota of grade 4. Here I'll read the next para, Your Lordship.
Yes.
It was also brought to the notice of the committee that the recommendation of the previous DPC meeting held on the 30th of November 2020 needs to be reviewed. This DPC where I have been recommended for promotion, Your Lordship.
Yes.
It may be mentioned that as per the decision of the earlier DPC meeting, Srimati Daritima Lingdo was recommended for promotion to the post of LDA from the quota of typists as per the provision of Rule 92 of the Meghalaya Directorate Establishment Ministerial Service Rule 2010. However, provision as laid down in the Government Office Memorandum number so-and-so dated 16/3/2006 was not referred to. As laid down in the office memorandum above at 5A and C, a typist who opts for grade system shall not be eligible for promotion to the post of LDA, irrespective of his or her seniority in the cadres, and the option once exercised is final. Here, Your Lordship, I would like to bring
You've already been reverted now.
Yes, already.
You never promoted, sorry.
Yes, never been. I've been promoted for 6 months. I've been in the promotion post. Thereafter, on the second DPC which was held, I was reverted back. Here I'd like to highlight, Your Lordship, even in the notice inviting me to appear for the speed test, there's nothing, no reference was made with regards to this office memorandum, Your Lordship. No reference was made to this office memorandum in the notice calling for a speed test, Your Lordship. The petitioner here is completely unaware of this office memorandum. They relied on this.
Now you mean to say that when the speed test notice is given to you, you're not aware that that this office memorandum will operate against you?
Yes, Your Lordship.
Once you offer a grade system, you'll no longer be entitled to any future promotion.
Yes, Your Lordship. And this notice also, nothing speak about that. In fact, they relied on this notification 5/12/2012, whereby the typist.
See, the very fact that where's the memorandum? See, this earlier judgment is there. You annexed it. Court has gone to this aspect also. Now, how did they address the representations?
They've just based on that same, upheld on the same, that office memorandum, Your Lordship.
You challenged the memorandum? You challenged
Yes, I've challenged, Your Lordship.
Where's the memorandum? Where is it annexed?
Office memorandum, Your Lordship. You'll find at page 46.
Page 46.
Yes, Your Lordship.
16 March 2006.
Now, where's the paragraphs which have worked against you?
5, Your Lordship. 5A and C.
You brought in authorities today. I've brought authorities, Ms. Longbury.
My authority is that, Your Lordship, I brought some authorities with regard to that position. It's a settled position of law, Your Lordship, where that the executive instruction can be applicable only in the absence of service rule, Your Lordship. And if there is a conflict between the executive instruction and the rules made under the proviso of Article 309.
Okay, before we come to authorities, one part is that, okay, fine, you say the office memorandum is very arbitrary.
Yes,
in the sense that you have not, enjoyed the fruits of the speed test, and you've been made to, to remain in the grade system.
Because all throughout, Your Lordship.
But number two is that now their order says that because that quota is not there for typists, it was for grade 4. That this it is too pronged now, because they said that their aversion is because there was no quota for typists. Correct? That's also what they say. 3 or there's no quota for typists, only for grade 4. Correct?
Is there, Your Lordship?
The quota post is there.
Yes, Your Lordship, is there.
How do you say that?
It's there, Your Lordship. If Your Lordship would come to.
They said that in that finding which you've read.
DPC. I'll just take, Your Lordship, to the first DPC, Your Lordship, which is at page 36, Your Lordship, where my promotion has been recommended. Page 36.
5.
Agenda number 5.
Yes.
Promotion to the rank of LDA. The department has 29 sanctioned posts of LDA as provided in the Rule 9.2. Typists who have rendered not less than 4 years of continuous service on the first day of the year in which the selection is made can be recommended to the rank of LDA. And as provided in Rule
9.3, selection can also be made from amongst the grade 4 employees of the Directorate who have passed HSLC examination or any examination declared equivalent thereto and have rendered not less than 7 years of continuous service on the first day of the year in which the selection is made. As provided in Rule 9.4, the quota to be filled in the cadre of LDA in any year shall be according to Sub-Rule 1, 2, and 3 in a ratio of 8:1:1, that is 80% by direct recruitment, 10% by promotion from amongst the typists, and 10% from amongst the grade 4 employees. Taking this into consideration, the breakup of 29 posts in the department will be as follows. Number 1, by direct recruitment, 23 posts, 2 by promotion from among typists, 3 posts, and 3 by promotion from amongst grade 4, 3 posts. Out of 3 posts, as per the quota of typists, 2 are existing vacancy due to superannuation of the previous incumbents and 1 vacancy resulting from the above recommendation for promotion. The committee, therefore, after scrutinizing the document of all incumbents in the select list, recommended Srimati
Now, okay, coming back, we'll just go another line. Coming back, now you say that the ministerial service rules as amended do not contemplate such office memorandum.
Yes, Your Lordship.
That's the only argument.
That is my ground, Your Lordship.
Does not contemplate such office memorandum cannot work against the rules.
The rules.
You know, in supersession of the rules. Since the Rule 11 does not contemplate such a situation. That a person has failed the speed test and remains the ones offered a grade. Now that OM, what is the basis for social life for that OM?
Lordship, that is prior to 2012, Your Lordship. This is.
But what goes against him also is that if that OM is existing, that means once you offer a speed test, that means you forgo your other
promotion.
If you see, if Lordship, can you see the office memorandum of 2006 and the rule of 2012, Your Lordship, is almost same. Your Lordship.
Where is that?
Lordship, kindly come to page 46 first. That is the
office memorandum.
Office memorandum 16 March 2006, yes. Your Lordship. Lordship, if Lordship is pleased to kindly come to 2B.
Yes.
Typist with a minimum 3 years qualifying service in grade 3 shall be eligible for appearing the 3 speed tests of 45 words per minute to be conducted by the Meghalaya Public Service Commission, and their placement in the grade shall be subject to passing the speed test. Then Lordship, kindly see that 3. Assisting ordinary grade typists who have already passed this, that will not be applicable, Your Lordship. Then 5A. A typist who opt for the grade shall continue to assert and he shall not be eligible for promotion to the post of LD assistant irrespective of his or her seniority in the cadre stroke service. Then Lordship, kindly come to page 31. Lordship, kindly come to amendment to Rule 11 and 2, Your Lordship.
Yes.
Typist grade 2, typist with minimum 3 years of qualifying service in grade 3 shall be eligible for appearing the speed test of 45 words per minute to be conducted by the Meghalaya Public Service Commission, and their placement in the grade shall be subject to passing of the test. So until and unless she passed the test.
No, come to 46 again. Come to 46 again. There's one, 36, sorry. 36, the office memorandum. See, what does it say? No, whether
B, Your Lordship.
No,
page 46, Your Lordship.
Yes,
Kindly come to B, Your Lordship.
Now you see, Mr. Shulai, what is, why the memorandum is what this court saying maybe has gone on about the rule C. Now you see 5B. See, the appointment of LD cadre shall be open to grade 3 typists until the and so. See the last one. The option once exercised is final. Now, where in the rules does it say that?
The rule is
that is what. Where is it silent? This one. Then it says that.
Lordship, kindly.
Okay, A, you say that she's fallen under this grade now, under 5A.
Yes.
A typist of the grade system shall continue as such, shall not be eligible for promotion to post LE assistant inspector. This also is not there in the rules, and C is not there also.
Lordship, kindly see the construction of the sentence made in 5/2/2012 at page 31, Your Lordship.
Yes.
Typists with minimum 3 years
Yes.
of qualifying service in grade 3 shall be eligible for appearing the speed test of 45 words per minute to be conducted by the Meghalaya Public Service, and their placement, Lordship, kindly see.
Shall be subject to passing the speed test.
Shall be subject to
That is
passing
what?
the speed test, Your Lordship.
Very clear. Nothing is silent
So
about
placement, the grade, will it be subject to speed test, or whether once you opt for the grade, you're out of contention?
Lordship,
That's the only
can
question.
you see here? She opted for that. She opted
That means that
for
we are,
that.
see,
She opted
memorandum
for
says
that.
Option exercise is final. Rules do not say
yes.
that.
She opted for that, Your
There's a
Lordship.
conflict in the rules and the memorandum.
Yes, complete.
She opted for that, Your Lordship. She opted for that, and she took part in the.
Correct. She opted for that. But the rules do not say that once you exercise option, it is final. So you're out of contention, out of the for the race for LDA and all. It does not say that. It says that type with minimum 3 years experience, qualifying service in grade 3 shall be eligible for appearing the speed test of 45 to be conducted by MPSC,
Lordship.
and their placement, the grade, shall be subject to pass speed
passing the
test.
speed test.
Otherwise, it won't be placed in the grade then.
Your Lordship, also once she fails in the test, Your Lordship, there is no scope for promotion, Your Lordship.
How can that be?
Does not
This
say
way
so.
also she loses, she's not placed the grade. That way also now if she doesn't pass, she's stuck there.
Lordship, then
I think
in that Lordship, then she may face again the same speed test to be conducted by the MPSC.
See, only that the office memorandum does not, well, the rules do not, have gone. The office memorandum rules have been amended later on 12. Now we have to read down the office memorandum then, because like you said, it's of 2006. If that is the case, you bring some authority, Mr. Not a question of executive orders, like in the presence of rules no longer apply. But in this case, they applied it. It's not a question of application, only one. They have tried to read conjointly.
I'll do that, Your Lordship.
Otherwise,
And the fact also, Your Lordship, it's not that we have given her also the ACP, Your Lordship.
then there will be an oppression of their service, no? Like it's discrimination. This matter for further hearing when? After 1 week. We'll finish it up next time.
Yes, Lordship.
Just bring some authorities.
Yes, Your Lordship, sure.
Get some research done also.
29.
Highly obliged, Your Lordship.
Apply, Your Lordship.
Where's the petitioner?
Who's here only?
No, should I get authorities also? That says otherwise. You have seen the observation of the court.
Yes, who's here only?
On appeal for the petitioner, this matter after 2 weeks is
30.
May it please, Your Lordship.
Where's
Mr. Sen was here, man.
you call him? It can be finished in 1 hour
Yes, Your Lordship.
easily. You're for whom?
And for private respondent number 7, Lord.
The one who got appointed.
Two of them got appointment, 6 and 7. 6
Who's
is
appearing
more
for 6?
crucial because
6. When the Changri so he's here. Anyway, let us start.
may it please,
Yes.
Your Lordship.
And MS Agarwal for the UGC.
For respondent number 5, my lord, UGC.
Very good. Yes.
No, sorry. The only thing, my lord, before my landed friends start, my lord, we are questioning the maintainability. So we'll have to get into the maintainability, my lord.
Have you raised it before? It's the
Yes,
first time.
Yes. I've raised in my affidavit. This spy office is not maintainable, so
So if he's challenging maintainability, then he'll have to argue the matter.
You start.
I'll say. Okay.
That means the court is to first go to exercise of deciding the maintainability, then coming to the hearing. Mr. Sen?
Lordship.
Okay.
No matter why we are questioning maintainability, they are challenging the appointment of private respondent number 6 and 7. Now, my lord, the admitted position is this thing, my lord. So far the writ petitioner is concerned, my lord, he applied for the post from the open category. He belonged to the general category and he applied for the open category post, for the post of geology. So far, my lord, 6 is concerned, my lord. He was selected from reserve category, OBC. No,
How many posts are there?
How many posts are there? Three posts are there. Now, my lord.
Okay, one second.
My lordship. If your lordship take up my affidavit filed by the university, my lord.
We'll see after statement. Let's start from there, then we'll understand.
Page 33, your lordship.
Yes. Zoology, where's zoology?
Annexure 2, page 33, my lord. This is 16 months. Online application are invited from Indian national for filling up the post of professor in various departments. Now, my lord, we are concerned with, my lord, zoology. That will be your lordship.
And serial 13.
Next, 35, your lordship. Serial number 13.
Okay.
Zoology. Professor 3.
Total
number of
posts.
posts.
The professor posts one.
Yes, man.
Okay, 3 posts.
3 posts.
1 unreserved.
1 OBC.
1 OBC.
1 EWS.
Okay, economically weak class. Okay. Yes, okay.
Now, my lord, admitted position, my lord, there is no dispute in the word. So far, my lord, the respondent number 6 is concerned, my lord, who was appointed professor of
Who is
geology.
going for number 6?
My lord, somebody, she is appearing. Now, my lord, he was, my lord, from the reserve category, OBC. Now, this is an admitted position. And I have made a, my lord, categorical statement in my affidavit also, why I am questioning the maintainability. Now, my lord, the law on this point is very well settled.
Okay, where's your affidavit?
It's not an admitted position.
Lordship will take my affidavit, my lord, at annexure at paragraph 5.
Yes,
my lord. That before answering the amendment made in the writ petition, the deponent questioned the maintainability of the writ. It is an admitted position the writ petitioner participated in the selection process and was a candidate from unreserved category. Being placed as such, he could not have challenged the appointment of private respondent 6, whose appointment is from reserve category. Thus, the writ petitioner being not a contender from the reserve category, he could not have challenged an appointment made in the said category. Further, having participated in the selection but not being successful, it is not open to the, well, that I am not going much. So my main contention is, my lord, admittedly, my lord, this is from a reserve category, so far 6 is concerned. He is from unreserved category. No, he could not have challenged. No, well, this is the subtle position of law.
What about 7?
7, my lord, he is. So far,
Then
7
it's
powers.
maintainable then.
7 they can, but then 6, how can it be your lordship?
Let's strike off 6.
Yes, my lord.
MS
Whatever, if your
strike
lordship
off
has
6.
is not maintainable, lordship will have to strike out. Now, my lord, this position, why, my lord, in 2007, in fact, a case was filed against the university, my lord. I was the lawyer, and my learned senior friend, she also appeared. There, the stand of the university, my lord, that person who filed the writ petition, he was not contended for the post, so not maintainable. That was accepted by this honorable court. Well, I have this judgment with me.
No, not contender for the unreserved post, fine, but for the other posts,
No, I'm not
for the OBC post, fine. But for unreserved posts,
yes,
then,
no, I have no problem. Lordship, that is to be decided, your lordship, because if it is not maintainable against 6, my lord, matter ends there.
yes,
they must be struck off.
then we strike off number 6.
May I reply?
Yes.
To this?
Number 6, we strike out number 6.
If your lordship, my lord, wants more decisions and all.
Well, let's hear first if it's a preliminary point only. If you only have that objection, that
because
number 6 is OBC and the petitioner's is an open candidate.
These are the facts.
So fine, they'll have quarrel only with one unreserved post.
Lordship.
Yes.
Lordship, would kindly look at the rejoinder filed to their affidavit, Lordship, to respondent number 1, 2 and 3. If your Lordship has got it, the rejoinder filed to the affidavit of 1, 2 and 3.
Yes.
Lordship, we had made an RTI application, Lordship, which your Lordship will find at Annexure 1, page 11.
Annexure
1, page 11. And this is the reply at page 12. Now, Lordship, kindly see list of applicants for zoology in the unreserved category.
Where is it?
Lordship has got that page,
Reply,
page 12.
Annexure 1, reply to RTI query.
Lordship.
Yes.
Next page, page 12 is the list of the candidates.
Yes.
Lordship, first is the unreserved category.
Yes.
Lordship will see number 7. Number 7 is Devendra Kumar Viswal, that is respondent number 6. So he has applied under the unreserved category. And
Also in the OBC category.
he has also reserved under the OBC category 2.
Yes.
Lordship has got it. Now, shortlisted for interview, Lordship. He's not shortlisted as an OBC candidate. Lordship will kindly see. In unreserved, he is at number 7 in unreserved category.
Yes.
And in OBC, he's at 2.
Number 2, yes.
So it cannot be his case that he is an OBC candidate.
No. For open category, anybody can open.
Lordship.
Can apply.
Lordship.
But he applies as open candidate, you mean? Showing that
he had
no,
this
but how is it possible that he can be in both categories unreserved?
that is the question, Your Lordship.
Yes.
If he is an OBC, if he's from the OBC category, he applies under the OBC category, which I cannot question admittedly.
Their names appear. It's
Lordship.
OBC Sundarej Selva Kumar.
Lordship, Lordship, the other
the
person is Mr. Timir Tripathi.
No, just come to the first one.
Lordship.
It's OBC list, like page 12.
Lordship.
Sundarej Selva Kumar, he appears in the unreserved also. Application.
No.
And Rupaknath?
No, Your Lordship.
And, okay.
Even for the shortlisted candidates, obviously they are not there because they are not in the main.
So the 3 people who apply in OBC are appeal shortlisted also?
Lordship.
Okay. Yes.
So, Lordship, that is why the contention of my learned friend that since he is an OBC candidate, I cannot challenge his appointment, cannot sustain, Your Lordship, because he has applied from the unreserved category.
Now this is the only contention you have.
And he's shortlisted and all.
My Lord, he has been appointed, Your Lordship.
No, is this only contention you have on maintainability?
Yes.
Then we discard that contention because this we have to go into this also.
No, my Lord, that's why I said, my Lord, I need to place the law.
Place the law.
Place the law. Because I'll argue on this point, my Lord.
Yes.
Now, my Lord, admittedly, my Lord, he has applied for both.
Then his application should be rejected under one of the one category or the other.
He has been selected, my Lord, from reserve category.
No,
that record
then how can you accept his applications unreserved at the same time as OBC?
My Lord, a person, Your Lordships, any person, my Lord, though he belong to a reserve category, Your Lordship, it is his option, my Lord, it is his liberty, my Lord, he can always participate in a open category, open selection, my Lord.
Of course. But the thing is that what about the other OBCs? They never put themselves under unreserved also.
My Lord, that is their choice, my Lord. If they do not,
then we see the records, the application.
Yes, I
whether
agree.
it's just an option you tick or whether you apply as an OBC.
We applied for OBC, my Lord.
No, what is the format like?
Format, my Lord, if Your Lordship want to enter record, I will place.
You'll have to bring the record.
Yes, I'll
because
bring.
this is the thing. Because with the now, how do you accept 2 applications?
Lordship.
Right.
Lordship.
I can understand if you apply in a form and you tick OBC, like scarce OBC, okay, whatever. And then when the general selection is done, you see, okay, this many posts for unreserved, this many posts for OBCs, many posts for STs. They pick out the ones ST on top, they get ST quota. The ones, or if the marks are qualifying, they go into the open category, unreserved category. Then the others go into. But then in this one we'll have to find. Yes.
This record I will place.
Okay, what law do you have to want to place?
Now, my Lord, the law is very well settled, my Lord. To challenge, my Lord, in service matter, my Lord, to challenge any appointment or selection person, my Lord, it can be only at the behest of a person who is aggrieved. Now, who is aggrieved, my Lord? If a person is not a contender for a post, my Lord, he cannot question the selection and appointment made in that post.
You mean to say
Now,
the representative of the contender for the post?
No.
How?
He is not for reserve category. He is not from the reserve category.
Correct.
My Lord, he is not from the reserve category. No, Lordship, here I need to place, my Lord. Now, he is admittedly, my Lord, he applied for the post of general from the open category, but he was not a contender for the post reserved for OBC, the post of geology. Now, here they admittedly, my Lord, that he was selected, my Lord, that record I will place from, my Lord, OBC category. So the writ petitioner, not being a contender to the post reserved for OBC, my lord, he could not have challenged. Now, my lord, a similar situation has come up before this one. This is part. There will be other decision also, my lord. I am relying on a decision, my lord, of this honorable, of the Common High Court, of course, my lord, 2007, involving the university. That was some appointment made in philosophy department. Now, there the question, my lord, I was the counsel appearing. We raised that question, my lord. Being not a contender of the post, my lord, he could not have challenged. Now the court has accepted my contention, my lord. That was dismissed. Then subsequently, my lord, of course, my lord, public interest litigation was also filed, challenging the selection. That too was also dismissed, my lord. So if I can, my lord.
See, Mr. Sen, this is two parts. It can just be an observation on the thing that they have no claim to unreserved post. But the bigger matter and controversy remains that there was no other candidate appointed in open category for which the writ petition is eligible for also. Correct?
Worship.
The writ petition is eligible for unreserved category. Correct?
Unreserved,
yes. And you appointed number 7 is under unreserved category.
7 unreserved.
Yes. Then?
No, 7, no problem. No, I'm concerned with 6.
Problem, then that is just...
No, my lord. He cannot.
See, Mr. Sel, just be a footnote. Okay, please.
No, my lord. My things will be, my lord. I have raised this issue of maintainability, my lord. So far, 6 is concerned, my lord. My lord, before your lordships gets into the merit of this case, my lord this court need to answer this. If it is not, if lordship may not accept my contention.
With the writ petition, yes. Yes.
No, my lord, this is 2007, 2 GLT, page 87. Madam, para 2, one over 0.
1 second.
No, sorry.
GLT. Yes.
Your lordship. From 2, paragraph 2, my lord, relevant parts done. The lordship has got it, my lord.
Yes.
Before adverting to the various contention raised by the petitioner in his writ petition, it will be appropriate to examine the standing of the petitioner to challenge the validity of the impugned appointment. This is necessary. If the petitioner is found to have no standing to file this writ petition, I need not deal with other points so raised by him. Ordinarily, it is the person aggrieved, directly affected, must seek the relief himself, unless disabled from doing so for a good reason which permits someone else to seek the relief on his behalf. In that situation also, the claim to be made in substance by the person affected, even though from be different, and it is to be stated expressly. In Mani Subramaniam joint case, the appellant has asked for a mandamus directing the respondent to appoint them to the post of additional district and session judge, etc. The Punjab and Haryana High Court dismissed the writ petition on the ground that the appellant had no locus standi filed the writ petition. The High Court had taken the view that the appellants were not appointed and had no right to be appointed, nor did they have the right to know why they were appointed. Dismissing the appeals filed by the appellants, the Apex Court held that the High Court rightly dismissed the writ petition. This is what the Apex Court says. The High Court rightly dismissed the petition. It is elementary, though it is to be restated, that no one can ask for a mandamus without legal rights. There must be judicially enforceable right as well as legally protected right before one suffering a legal grievance can ask for mandamus. A person can be said to be aggrieved only when a person is denied a legal right by someone who has a legal duty to do something or to abstain from doing something. The question, number 3, the question of locus standi again came up for consideration before the Apex Court in Ghulam Qadir case, cited by the Learned Counsel for the respondent university. While duly noting the recent far-reaching changes in the orthodox rule of interpretation regarding locus standi, the Apex Court observes at para 38 of the judgment as follows. There is no dispute regarding the legal proposition that the right under Article 226 can be enforced only by an aggrieved person, except in the case where the writ prayed for is for habeas corpus or quo warranto. Another exception in the general rule is the filing of a writ petition in public interest. The existence of the legal right of the petitioner which is alleged to have been violated is the foundation for invoking the jurisdiction of the High Court under Article 226. The orthodox rule of interpretation regarding the locus standi of a person to reach the court has undergone a sea change with development or constitutional law in India, and the constitutional courts have been adopting a liberal approach in dealing with the case or dislodging the claim of a litigant merely on hyper-technical ground. If a person approaching the court can satisfy that the impugned action is likely to adversely affect his right, which is shown to be having source in some statutory provision, the petition filed by such person cannot be rejected on the ground of his not having locus standi. In other words, if the person is found to be not merely a stranger, having no right whatsoever to any post or property, he cannot be non-suited on the ground of his not having locus standi. The question...
Now, okay, one thing, Mr. Sen, that this case, at a point of time, was it challengingly one private respondent? Upon one private respondent, or as the case presently before us now, where there are two private respondents? At that time, was it one or two? If you see, if there's no relief claim against that person or can be got against that person, then it's not maintainable, right? But in this case, it's a mixture. It's not. No. If it's a mixture in the sense, yes, might be maintainable against number 6 because for whatever reasons, which the court will examine also after seeing the applications.
No, that is
if you have no quarrel with the fact that it is maintainable as number 7, then we can go ahead. You produce the records, we will take it up. We will examine. We'll examine the applications. We don't want entire records. Just the application forms of this respondent number 6. You have it with you, Mr. Changreso?
Well, I have annex in my affidavit.
The application?
Well, all the applications I have annex.
But we can look at it now, yes. Where is, huh? Yes, just show that. We'll sell the issue first. Penny affidavit. On.
My notice is inquiring about my application response to the advertisement.
Yes. Where is that? Yes. You filed on 5th March. Yes, got the affidavit by respondent number 6.
Page number 59.
Of your
Office C. Annex 4.
And where's the other application under unreserved?
Well, that is page number 76. There are 3 decisions are there, so we want to see please put that explanation regarding the locus.
No. Now, okay, fine. This is your first application, 59, Devendra Kumar Biswal. Yes. Category OBC, okay.
And the 76, man.
76. And?
76.
Okay. Page 76. Just wanted to see, actually. Yes. Yes, please, let you submit. Yes, how is this permissible and what?
And in fact, in our affidavit, categorically you stated that he applied for general, unreserved as well as reserved. It's not the question, my lord, that we are holding back anything else. Yes. I've categorically stated in my affidavit.
Yes.
So, my lord, what is your lordship's mind, my lord, if I get it correctly? Now, what he sought? He sought quashing the appointment of both 6 and 7. So, my reservation is here. If it is not maintainable with 6, my lord, we need not go further. Now, so far 7 is concerned, but he is from open category, definitely your lordship will examine.
So, we'll examine that.
Lordship will
so, are the qualifications of this number 6 a question?
Very
Obviously,
much,
my lord. Because
very
they are
much
basically, my lord, more on 6 than 7.
But lordship, this goes beyond all this, because it is not only that I have challenged the appointment of 6 and 7 now. Lordship will kindly remember we have approached this honourable court in an earlier writ petition challenging the very selection process, your lordship. That is very pertinent now. May I or your?
No, only thing, lordship, since we are on maintainability, because
no, I'm answering him on maintainability, lordship.
What, my lord, it come at the threshold, my lord. Once we cross over the maintainability,
please,
obviously, Lordship,
No,
other thing also.
I'm answering him on this issue of maintainability,
Your
Lordship.
judgment saying that if no relief can be claimed against, so the respondent repression of maintainable. Fine. Yes, John, what judgments do you have?
Please, Chief.
Yes.
My lord, I will cite the 2013 volume 4 is a C. So this is also similar, my lord. The general category has a filed writ petition against the appointment of ST.
Give me the page number.
My lord, page number 465, 2013 volume 4, SEC, page number 465. Relevant para, my lord. We come to relevant para 6 first.
Para?
Para 6, just the brief background, the nature of the facts of the case. Para 6. Para 6, madam.
Yes.
Mr. A.V. Savanlarat Senior Counsel appearing for the appellant has submitted that respondent number 5 does not belong to reserved category. In fact, he belongs to the general category and hence he has no right or locus standi to challenge the appellant's certificate. Thus, the High Court committed an error by directing the scrutiny committee to entertain the complaint filed by respondent number 5. It has further been submitted that despite the direction given by this court, the scrutiny committee failed to ensure compliance with the principle of natural justice, as the appellant was denied the opportunity to cross-examine the witness, and no order was passed with the such matter. May I come to the relevant one? This is the back of the case. And now the Lordship, we kindly come to para 9.
Person aggrieved.
Person aggrieved. The legal proposition that the stranger cannot be permitted to meddle in any proceeding unless he satisfies the authority court that he falls within the category of aggrieved persons. Only a person who has suffered or suffered from legal injury can challenge the action, order, etc. in court of law. A writ petition under 226 of the Constitution is maintainable either for the purpose of enforcing statutory or legal right, or when there is a complaint by the appellant that there has been a breach of statutory duty on part of the authorities. Therefore, there must be a judicially enforceable right available for enforcement on the basis of which the jurisdiction is not resorted to. The court, of course, enforces the performance of statutory duty by a public body using its jurisdiction at the behest of a person, provided such person satisfies the court that he has the legal right to insist on such performance. The existence of such a right is a condition precedent for invoking the jurisdiction of the courts. It is implicit in the exercise of such extraordinary jurisdiction that the relief prayed for must be one to enforce a legal right. In fact, the existence of such a right is the foundation of the existence of the said jurisdiction by the court. The legal right can be enforced must ordinarily be the right of the appellant himself, who complains of infraction of such right and approaches the court for relief as regards the same. A legal right means an entitlement arising of legal rules. Thus, it may be defined as an advantage or a benefit conferred upon a person by the rule of law. The expression person aggrieved does not include a person who suffers from a psychological or imaginary injury. A person aggrieved must therefore necessarily be one whose right or interest has been adversely affected or jeopardized. In such case, view was taken by this court, observing that if a person claiming relief is not eligible as per requirement, then he cannot be said to be a person aggrieved regarding the election or selection of the other persons. Since that aggrieved person denotes an elastic and elusive concept, it cannot be confined within the bounds of rigid, exact, and comprehensive definition. Its scope and meaning depends on diverse variable factors such as the content and intent of the statute of which the contravention is alleged, the specific circumstances of the case, the nature and extent of the complainant's interest, and the nature and extent of prejudice or injury suffered by the complainant. I come to the forward level page, para 17. In view of the above, the law on the said point can be summarized to the effect that a person who raises a grievance must show how he has suffered legal injury. Generally, a stranger having no right whatsoever to any post or property cannot be permitted to intervene in the affairs of the others. As regards respondent number 5 does not belong to the ST category, the gap adopted by him of serving the cause of ST tribe candidates who might have been deprived of their legitimate right to be considered for the post must be considered by this court in order to determine whether respondent number 5 is in fact a legitimate person to lay any claim before any such forum. Now, I'll come to the para 48 and 49.
Yes.
Para 48 and 47 and 48. The appeal is disposed of accordingly. However, considering the fact that respondent number 5 has not been pursuing the matter in bona fide manner and has not raised any public interest, rather he abused the process of court only to harass the appellant. Respondent number 5 is restrained from intervening in the matter any further and also from remaining a party to it, and he is also liable to pay costs to the tune of ₹1 lakh within a period of 2 weeks to the district collector. But the cost was imposed. So here also, general candidate has challenged the appointment, the caste certificate of the ST candidates, and on the basis of the caste ST candidate certificates, he was appointed. So he challenged that one. So this is a court judgment, my lord. Second judgment, my lord, may refer to 2006, volume 8, page number 212. 212. Relevant para, my lord, may I take para 60.
60.
60, my lord. My lord, the reason I cite, my lord, I put up the application under the unreserved also. That doesn't have any legal consequences.
That is what this court want to hear.
Without that also, my lord, I'm eligible for appointment against the unreserved post, provided I secure the higher marks than the general candidates. My lord, page 60, para 60, may I come?
But is there a provision that you apply separately for OBC, or you apply just for one category and just write OBC? You can write, you can be, because selection is across the board.
Right.
Correct. Right. It's only a certain post as per the roster is reserved. Doesn't mean that for OBC candidates, special selection, special set of requirements, criteria, and for unreserved, no, it doesn't work that way. The thing is that general selection is that suppose out of a pool of 10 people who apply, might be some are open, some are scheduled caste, some are scheduled tribe, some are OBCs. Then if the list comes out, if there's 6 vacancies in order of the roster, then they're given.
Yes.
And so in order of the roster, so the top unreserved people will go on the open list.
Right.
Then if the SC's candidate happens to be top also, then as happens in Meghalaya all the time, he goes on the open list.
Right.
And those other reserve categories still remain open for accommodation of the other people. There's not a case where you write, I'm applying as an OBC candidate. Then, suppose there's no quota of OBC at that point of time, you won't be considered.
Here the advertisement is, my lord, one post for OBC.
Okay, I will learn that. Let's not argue. Let's see 60.
My lord.
Indra Soni.
Indra Soni, referring to Indra Soni, my lord,
Yes.
the Nagaraj bench, church. It is a church bench of passed in Nagaraj case, 5 church bench, my lord. My lord, in Indra Soni, Chivandi.
Exactly what I'm saying just now. Exactly. If you get selected unreserved, doesn't mean that you eating into the quota. That's all.
No,
Yes.
May I just read out this portion?
Yes.
That reservation under Article 16.4 does
16.4,
not operate on communal ground. Therefore, if a member from a reserved category gets selected in general category, his selection will not be counted against the quota limit provided to his class. Similarly, R.K. Saparwal, the Supreme Court held that while general category candidates are not entitled to fill the reserved posts, reserved category candidates are entitled to compete for the general category posts. The fact that considerable number of members of the backward class have been appointed, promoted against general seats in the state services may be a relevant factor for the state government to review the question of continuing reservation for the said class. Therefore, my submission regarding the dates is, in the advertisement, one post for OPC. So I applied for mentioning this OPC category. Now, subsequently, I realized that I need to, if I perform better, good, I may also compete for the reserved category also.
Doesn't work that way.
My lord, therefore, it is not necessary. Second application
Doesn't work that way. Doesn't work that way, Mr. Charissa.
Therefore, the second application I put up for unreserved, it has no legal consequence. Without that also, if I perform better, Lordship has pointed out correctly the law, if I outshine than the writ petitioner, I can occupy the reserved post. So
the unreserved post, yes,
unreserved,
of course.
Unreserved. So the second application put up by me has no legal consequence. Without that also, he can pursue. he can participate.
So for the other OBC candidates, they apply strictly under OBC only.
OBC, my lord.
The other two.
But normally, my lord, they do apply because they know very well that there is a seat for OBC. Therefore, they
No, you apply strictly against OBC quota only. Suppose you don't get selected under OBC quota, you're out.
My lord.
Because that doesn't mean that way. That's just the selection is general. You have your score. I mean, you go for the interview board or you sit for the score, you qualify, then fine. You know, there's a cutoff mark.
My lord, what the lordship is very averse. For example, the UPSC, when the ST candidates appear, my lord, they go along with the application with the ST certificates.
Yes, it's just you tick the box.
My lord, they tick the box, tick the box. So without particularly mentioning reserve, or
you don't have to say that this I'm applying a ST certificate. No, as a ST, no.
No, therefore the lordship may examine whether.
For example, I don't think I've used my ST status for anything. Even for application for law university, it's just you apply. That's it. And if you have the, you go for the small interview and all. If you qualify, you qualify. You're being STs. It's like it's not that. Then the second list comes and okay, fine, there are reservations for scheduled tribe. Then other people have. So it's like that.
Right.
You don't have to write that you just have to tick that you're an ST. That's all.
Without writing also, my lord.
You just have to tick. I mean, very ST or unreserved. Yes, tick that.
My lord, that is my application amounts that ticking up that category. My lord, the first application I put up mentioning the OPC, that amounts to ticking that box that I come from the background, the OPC background. That's the only indication. That doesn't affect any candidate.
Next decision.
Next decision, my lord. I'll come to. My lord, that is a judgment made. My lord, this I'm supplying to the court master, the next judgment. Order passed on 28 April 2022. My lord, I may come to relevant para 8.5.
This is a correct judgment, because live law is very dodgy.
My lord.
Because I'll say what happened from personal experience. There's some when we pass some judgments, we quote some judgment, right? And then when compared with the official reporting and the live law reporting, the paragraphs are different, the wordings are different also. You ask my PS.
Right. That happens, my lord.
That's what live law is very dodgy.
But that happens.
Yes, I hope it's correct, yes.
Your lordship permits me.
Yes.
Para 8.5.
Yes.
This is in a more recent decision in this court in the case of Sorapiata versus Sansa 2021, after referring all the earlier judgments on vertical reservation, has observed and held that it is well settled that the candidates belonging to any of the vertical reservation categories are entitled to be selected in open or general category. And it is also further observed that if such candidates belong to the reserved categories are entitled to be selected on the basis of their own merits, their selection cannot be counted against the quota reserved for the categories that they belong. Similar view has been expressed by this court in another recent decision of this court in the case of Such. By the such decision, it is reiterated that the reserved category candidates securing higher marks than the last of the general category candidates are entitled to get seat posts in unreserved categories. It is further observed and held that even while applying horizontal reservation, merit must be given precedence, and if the candidates who belong to SC, ST, OPC have secured higher marks or more meritorious, they must be considered against the seats meant for unreserved candidates. It is further observed that the candidates belonging to reserved categories can as well stake claim to seats in unreserved categories if their merits and position in their merit list entitles them to do so. I may not go to the reiteration of the law points, madam.
Very interesting case as well.
Well,
because it's two OBC candidates, they came number one, number two.
Yes.
And people who are already serving there, who waiting accommodated were general category, they are number one, number two.
Right.
Yes.
Well,
because you see, once you qualify an open category, doesn't mean that the reserve category, gets, that it gets exhausted. Doesn't mean that. A reserve candidate can sit for unreserved posts, correct? But doesn't mean that, if he's not appointed against that OBC post, that OBC post goes, that vacancy goes.
My lord.
Anyway.
Here was exactly, my lord. Para 9 indicates, my lord.
Okay.
The OPC candidates, 2 candidates outside.
Yes.
The general candidates. My lord.
Okay, yes.
And the other questions,
Live law.
my lord, 2012 volume 4, page number 407. And may I take the relevant para 58 and 59.
Para 59.
58 and 59, ma'am. Para 58 and 59. With your permission, may I read?
Yes.
Sri Chandaman Sansad, ex-president, was the complainant. Thus, at the most, he could lead evidence as a witness. He could not claim the status of adversarial litigant. The complainant cannot be the party to the lease. A legal right is an averment of entitlement arising out of law. In fact, it is a benefit conferred upon a person by the rule of law. Thus, a person who suffers from legal injury can only challenge the act or omission. There may be some harm or loss that may not be wrongful in the eye of the law, because it may not result in injury to a legal right or legally protected interest of the complainant, but judicially harm of this description is called such. The complainant has to establish that he has been deprived of or denied of a legal right, and he has sustained injury to any legally protected interest. In case he has no legal back for justifiable claim to hang on, he cannot be heard as a party in a lease. A fanciful or sentimental grievance may not be sufficient to consider a local standing to sue upon the individual. There must be injury or a legal grievance which can be appreciated and not such a claim of devoid of reasons. Therefore, my humble submissions, challenging my appointment by the writ petitioner is absolutely, my lord. No legal injury is caused to the writ petitioner because I was appointed for the OPC category. Therefore, arraying me as a party is in fact abuse of the process of this honorable court, apart from harassing the respondent.
Have you made that averment in affidavit?
Madam.
That you've been wrongly arrayed as a party?
Yes, madam.
Then fine.
May I come to that relevant para? Para 8, madam.
Para 8.
Madam. I sought my para 4, I stand corrected. Para 4.
Okay.
I make a specific averment that I should be strike out. Oh, the writ is not made in Nepal. Para 4, madam.
Yes.
With lordship permission.
Yes.
Before reporting the merits of the case, the answering deponent begged to raise the preliminary issue that the answering deponent is wrongly pleaded as respondent number 6 in the writ petition by the writ petitioner for the simple reason that he had applied the application that is answered as OPC candidate along with another application search for unreserved category. However, the answering deponent was selected and appointed as professor in the Department of Zoology under OPC reserved category right permission search. And immediately the writ petitioner is not the OPC candidate, and therefore the writ petitioner has no locus to challenge the selection and appointment of the answering deponent before this court. And hence the answering deponent is wrongly arrayed as a respondent number 6 in the instant writ petition, and as such this oral court may strike off the name of the answering deponent from the area of parties in the writ petition, as he is neither a necessary nor a proper party in the writ petition for the ends of justice. So, my lord, this is my primary issue I raised before entering into the merits of the case.
Have the reply?
Lordship, the little that I know of this kind of selection process, Lordship, if your Lordship refers back to the list which I was referring to in my rejoinder, your Lordship, these cannot be parallel selection processes which are going on in the university, your Lordship. It cannot be a selection process for the OBC which is going on and a selection process for the general category is going on, Lordship. Lordship, and more so when this respondent number 6 has applied also under the unreserved category, your Lordship. So the little that I know, your Lordship, as your Lordship was pointing out just a little while back, on the basis of merit, a merit list is prepared, Your Lordship, which is a one common list, Your Lordship.
Yes.
And which is substantiated by the judgment which my learned friend has referred to just now.
Live law judgment.
Live law judgment, Lordship. May I read that judgment, para 9? Lordship, because here the two OBC candidates, Your Lordship, because they came on the top of the list as 1 and 2. So they were to be accommodated in the unreserved list, Your Lordship, which would have left some vacancies for other reserved category candidates to be accommodated. So, Lordship, my little understanding is that, first of all, a common merit list is to be prepared by the selection committee. It cannot be an OBC list and it cannot be an unreserved list. I think we are opening up a Pandora's box unwittingly by referring to this very list.
Yes.
Lordship, para 9 of the judgment which my learned friend just referred to, may I read, Lordship? Applying the law laid down by this court in the aforesaid decisions to the facts of the case in hand, it is noted that the aforesaid two candidates, namely Mr. Alok Kumar Yadav and Mr. Dinesh Kumar, belonging to OBC category, were required to be adjusted against the general category, as admittedly they were more meritorious than the last of the general category candidates appointed, and that their appointments could not have been considered against the seats meant for reserved category. Consequently, after considering the appointments in the general category, the seats meant for reserved category were required to be filled in form and amongst the other remaining reserved category candidates on merit, such as respondent number 1 herein. If such a procedure would have been followed, the original applicant, respondent number 1, would not have got appointed on merit in the reserved category seats in the vacancy caused due to the above procedure. Therefore, as such, the High Court has not committed any error in observing and holding that the aforesaid two candidates, namely Mr. Alok Kumar Yadav and Dinesh Kumar, will have to be adjusted against the general category candidates. And accordingly, respondent number 1, being a reserved category candidate and being at serial number 1 in the waiting list of reserved category, was to be appointed. Lordship, I refer back to the list again. If your Lordship kindly sees the name of respondent number 6 in the unreserved category, Lordship, he comes at number 7. He's high above in the list.
When he rejoined, where is that?
The page 12 of the rejoinder.
Yes, yes.
So, Lordship, if a common list is prepared in order of merit, respondent number 6 would be high on the list and he can well be accommodated in the unreserved category, Your Lordship.
Yes.
Because Your Lordship will also kindly note, other than Mr. Devendra Kumar Viswal, nobody has been appointed.
What about this number 1?
That's Tripathi, that's the other one, Your Lordship.
No, this in the OBC list.
In the other...
They didn't qualify.
No, in the other thing,
No,
Lordship...
after the finals, like, they were shortlisted, okay.
Lordship, now the shortlisting...
For interview, after interview only he qualified.
Lordship, shortlisting is again the same names are... how can the same names be shortlisted? Because if it's on the basis of... Because they have to qualify, Your Lordship, as per the UGC regulations. It is not at the whims and fancies of anybody.
The court accepts your point. There can't be two
parallel selection
You
process.
can't have, like, suppose you've been shortlisted for the unreserved interview. You go on an interview. Okay, now it's over. Now we'll have
So
OBC
you are
interview. You come for OBC interview.
Lordship.
That makes no sense.
That I have not come across, Your Lordship. Because if it's a selection process, everybody is in the same queue, Your Lordship. After the merit list is announced, Your Lordship, then in order of merit, Your Lordship. And if this person is high in the merit list, he can, because he's contested from, I'm not using the word contested because of the election fever, I guess. If he has applied under the unreserved category, Lordship, he could well have been accommodated under that list, Your Lordship, as per the judgment cited by my learned friend.
Yes. It's strange that two applications are there for OBC. Anyway.
And two parallel processes are being carried out, Your Lordship, for selecting people to the post of professor. What is even more interesting, Your Lordship, is under the unreserved list, number 2, Your Lordship. One is Tripathi, that is respondent number 7. What is very interesting is Manas Kumar Santra.
Yes.
Now, interestingly, Mr. Manas Kumar Santra is from chemistry.
No, we go to maintainability part.
I'm on maintainability, Lordship.
Okay.
I'm on maintainability, Your Lordship, because they are
What is this
saying
Manas Kumar Santra a party here in the proceedings?
he's not a party, Your Lordship,
Then?
but he goes to the root of the case. We had approached this court saying that people who are not eligible for the post of professor in Department of Zoology cannot be called for interview.
Okay.
Manas Kumar Santra is from chemistry,
Okay.
admittedly. Now, the case of the respondent Nehu, Your Lordship, in that earlier round of litigation, before Your Lordship, is that people from allied categories can be called. In fact, I'm making a bold statement, Your Lordship. This Honorable Court has been misled into believing that the selection process was proper. Because this Honorable Court was led to believe that all the candidates who have been shortlisted for interview are from allied categories, Your Lordship. Now, they themselves, Lordship, I'll just take Your Lordship to the judgment passed by Your Lordship in this earlier round. Page 61 of the writ petition.
Where? Page?
61 of the writ petition.
Yes.
Lordship, para 3, I'm just coming down to 1, 2, 3, 4, 5, 6, 7, 8, the line starting with the learned counsel submits.
Yes.
If Your Lordship has got it.
Yes.
The learned counsel, that's Mr. Sen, the learned counsel who submits that zoology is a part of School of Life Sciences, which also includes biochemistry, biotechnology, bioinformatics, and botany department.
Yes.
These departments he submits coming within the umbrella of School of Life Sciences. Applicants, therefore, who possess allied, connected, or relevant disciplines qualifications were eligible and have been found to be so by the expert body that screened the candidates. This was what was informed to the court, Your Lordship.
Yes.
And on that understanding, that all the candidates who have been screened are from these 4, Lordship was pleased not to interfere and also imposed costs on us.
Yes.
Lordship, Your Lordship's findings at para 8, page 63.
Yes.
Lordship, the second line of that para, the School of Life Sciences, having included other departments such as biochemistry, biotechnology, bioinformatics, and botany departments, apart from zoology, it would follow, therefore, that the candidates possessing PhD in these departments can also be considered for the said post.
Yes.
So, Lordship was under the impression that all the candidates shortlisted are from these 4. Whereas, Manas Santra was admittedly, and that is what we've been screaming from the rooftop, people from chemistry have also been shortlisted for the interview. And now, Your Lordship, he's not only been shortlisted, he's been kept in waiting also, Your Lordship. I have annexed that in my rejoinder.
So you mean he has a can of worms?
So, Lordship, I'm only not challenging the appointment of 6 and 7, I'm challenging the very selection process.
The bigger picture.
Lordship. Lordship, in the rejoinder which I had filed, Your Lordship will kindly see that Manas, page 14, Your Lordship.
Yes. Yes.
Names of the waitlisted candidate, Lordship. Manas Santra.
Yes.
This is after the selection, Your Lordship.
Professor under? You are unreserved.
For the post, Your Lordship. That is the post. But he is from chemistry, Lordship. That also I have annexed.
Yes.
Now, but even before I go that, just to satisfy Your Lordship, that chemistry is from a totally different school, Your Lordship. Just 1 minute, I'll take Your Lordship to the various schools, Your Lordship. Lordship will kindly find that at page 58, annexure 6 of my writ petition. Lordship, these are the various schools, departments.
Physical sciences.
Lordship, first column under 3, School of Life Sciences,
Yes.
Biochemistry, Biotechnology and Bioinformatics, Botany and Zoology. These are under Life Sciences, Lordship. Lordship, just on the right of your Lordship is please to see below School of Humanities, a School of Physical Sciences.
Yes.
Lordship, kindly see Chemistry Department, Mathematics, Physics, Statistics. Chemistry is admittedly from the Department of
Physical Sciences.
And not from Life Sciences. That is why when the matter was being heard, your Lordship had asked them to produce the records, and we were insisting that they file an affidavit, which they did not. And on this wrong assumption that only people from School of Life Sciences have been applying and shortlisted, this Honorable Court did not interfere, which in my humble submission was not expected of Nehu, to say the least.
Anyway, we'll hear the matter. I'll hold it be maintainable. I'll pass the order.
Lordship,
Yes.
may I pray one thing, Your Lordship? I will just make a prayer before this court. Lordship, my Lord, before we get into merit, Lordship will decide on this maintainable.
No, we'll decide.
Yes.
Decide it. I
So
mean, the orders will follow. This court will hold it maintainable.
Yes.
With
As
the
regarding
larger picture, yes.
Yes. My Lord, as regarding other thing, now my learned friend, my Lord, here, my Lord, only she has questioned the appointment of respondent number 6 and 7. Now she is bringing somebody who is in the waiting list. Now, my Lord, suppose your Lordship do not accept my contention on maintainability. Lordship wants to go into the, my Lord, what are the qualifications?
No, we'll go into the merits, yes.
Lordship, go into the merits. Now, my
Well,
Lord,
see, the larger picture is what? On maintainability, why? Because as this court observed earlier on, how can a person apply as an OBC?
my Lord, I'll clarify.
Number one, how can he apply as unreserved? And where's the common list?
Lordship.
Yes, all selections go like that.
Lordship. No, Lordship, here,
And so-
you, my Lord, admitted position is
And
this,
she's
my
correct,
Lord.
the judgment produced by Mr. Changre, so it is the law. That's all.
There is no, my Lord, the only thing, your Lordship, the only test here, your Lordship, which your Lordship will apply, the writ petitioner is she a contender for that OBC post. Now, suppose, tomorrow, my Lord, after hearing on merit, Lordship find, my Lord, something.
We find the whole selection process vitiated, then OBC or no OBC, UR or no UR or EWS, all goes.
No, my Lord. Yes. Is it under challenge? No, it's not. Well, is it under challenge, your Lordship? Now, the question is, tomorrow, your Lordship, for some reason, my Lord, I'm not saying, say that his appointment is not correct, appropriate. My Lord, what benefit a writ petitioner
It's
will
not a
derive?
question of not correct.
This is not a public interest litigation.
It's
It's
a
not
public
easy.
litigation,
It's not a
yes.
public interest.
Correct.
I come and challenge
Correct,
6 and
correct,
7.
correct.
Then I make a submission and the court will
have
say, no,
said-
I'll go and look
we
into
have
the
not-
entire
We
selection.
have not gone there, Mr. Senior, yet.
Lordship.
We decided on maintainability, that's
Exactly.
all. And
That's-
the
that's
court,
why, your Lordship, I do
rule
not-
maintainability in favor of the petitioner, and we'll hear the
No,
matter.
Lordship,
Yes.
what,
Because there are many questions.
So
The
for,
questions still left open, right? You're still at liberty to argue the points you're
On
raising today
maintainability.
also.
On
Yes, but then like as of now, I'm going to hear the entire matter. That's all.
as of now, your Lordship,
My Lord,
Yes.
averment I've gone through. There is no averment challenging the entire selection.
it's not there, my Lord.
Doesn't matter.
This
we'll
is
hear
not
it,
a
we'll
public.
hear it,
No,
we'll
Lordship,
hear it.
Lordship, my Lord,
Obviously,
only
this is
thing,
not
my
a
Lord, the
public
only thing which is not.
Something, Mr. Sen, like which has disturbed the court is that even though that Patra is not a party here,
Lordship.
but if that's the submissions you made at the bar that all applicants, that has disturbed the court in the sense that all applicants from the School of Life Sciences,
Lordship.
and that is not correct,
Lordship, first, just
then the court can reach out his hand, because if the court has been, if it has been made to pass an order under assumption and presumption on the submissions of the councils that this has happened.
Lordship, I'm just bear with me for a second. Lordship has passed an order. Now she is saying this is a wrong order. Has any point of time, I have made a categorical, has she filed an appeal? This
Even
court
then,
will not
this
give
court
indulgence
will
to
take
this kind of
notice.
submission.
If any kind of,
This
we're not
court should
gonna
not
go-
give indulgence.
We're not
my
good.
humble
No,
submission.
it's not the court should not. Why court cannot?
Has she preferred an appeal, my lord?
We're not
She has not
we're
preferred an
looking at
appeal.
petitioner. If that is a fact,
Just
if
coming, my lord.
statements are made
And
at the
I'll
bar-
submit, my lord. This is whatever submission we made are correct and based on records.
Yes.
But the question,
We will
only
look at
question,
that.
only
We will
confusion,
look
my
at
lord,
it.
only confusion is not clear that are we on maintainability or going into the marriage?
We'll go to the merits. We keep a question open.
Maintainability will remain open.
Yes, remain open. We'll decide it finally with the merits of the case.
First merit, then maintainability. Normally,
No,
maintainability.
together. It's in final hearing. We'll hear it. Yes.
Just one defect, Lord. The petition served upon me, Lord, has 65 pages, which ends at Minister 8. And inside the reading is 9 and 10. If that can be supplied, because it appears
You can supply it.
everybody's copy is the same, Lord.
Yes.
Ends at page 35.
No, but I think we'll look at the
We'll
whole
look into
thing.
it. I'm sorry if that's happened.
Why?
why we have to look at the entire picture?
Entire selection.
Yes. That will look good.
My lord.
That is the why of it.
Lordship, what is very interesting is the students of that department has lodged a complaint.
That's outside.
I brought it on record, Lordship, because...
We'll examine that. We'll examine the whole thing. We'll start from point A.
Lordship. Obliged, Lordship.
It's just that you heard the submissions on maintainability of the writ petition, especially against the whether, in as much as no relief can be obtained against respondent number 6, who stated to be who are said to be appointed against the quota of OBC, whereas the writ petitioner is an open candidate. Stop. On hearing the submissions of the council of the parties, it appears that the initial application, as also the lists prepared, are interlinked and interconnected, notwithstanding the fact that the respondent number 6 belongs to the OBC. This is the matter will take up on merits. The question of maintainability will still be open for argument by the respondents. Yes. We'll have it. Yes.
Obliged.
Listed when?
As and when, Lordship. Next week.
Next
because
week.
the students are suffering admittedly, Lordship. I have documents to establish that.
My lord, all, my lord.
If my learned friend says that, Lordship, I'll take your Lordship to one line.
I have the records.
Just one line.
I have the records, man.
After,
I have the records.
listed on so-and-so week, yes, or 1 week. Yes.
Obliged, Lordship.
After a week.